If you're going to drive, you must have liability insurance in your name. You understand?
Yes, sir.
All right, come on.
Judge, while we have Luis, want to go ahead and do all of
Yeah.
the speakers?
For sure.
Okay,
For shizzle.
Castellanos on page 2. You want to bring them all up at once?
Let's do it. Or how many do you have, I guess?
3.
Yeah, that's fine.
Garcia Mendez on page 7. Mendez,
Castellano, Garcia Mendez, come on up. Vente, por favor.
Rodriguez, Gallego on page 16.
So Castellano, we don't have.
Rodriguez, name. Rodriguez,
Who is Castellano? Castellano. Okay, Castellano, ponte aquí, por favor. And then, ¿cómo te llamas? Garcia, and then Rodriguez. So we'll do in alphabetical order. Do you have cause numbers for all of them, or do you need it? Okay. Gentlemen, each of you have picked up criminal cases. You are charged. We are going to do probable cause. Each of you have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay,
Starting with Castellano.
sure.
On May 22nd, in Harris County, officer dispatched to a suspicious person's call regarding a vehicle recovery and chop shop with stolen cars. Officer arrived on scene, attempted to make contact with the defendant, who was on property and appeared to be working on a motor vehicle. Defendant saw the officers and fled on foot. Officers lost sight of him. Later that evening shift deputies received another call for service at the same location, advising that the defendant who had fled earlier had returned and was loading stolen motor vehicle parts into his truck. Officers established a perimeter, announced themselves. The defendant then fled on foot, was tracked by a drone and seen jumping fences before being located and detained about a half mile away.
Is this the only charge that we are expecting?
As of right now, Judge, yes.
Sir, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you're ordered not to go back to this place and not to engage in any illegal activity. If you do, I will revoke your bond and put you in jail. On each of you, I don't know what your immigration status is, but if I have to put you in jail and immigration finds you and you are not in this country with proper permission, they will put a detainer on you and you will be stuck like Chuck for who knows how long. And then you get shipped off to immigration after a good 6 months here. Well, you'll wait for another couple months. Don't endanger my city. Do you understand?
Yes, sir.
So, Mr. I think it was Guzman, right? Guzman or what? Garcia.
I'm seeing the system on Garcia Mendez. He has this printed only. It's not printed docket, but it's in the system.
I guess we'll go to the last one and then we'll just have him take a seat.
Garcia Mendez.
Toma asiento, vamos a esperar para tu abogado. And this gentleman is who again?
Rodriguez, Gallego, and he's on page.
Got it.
Top of 16, Judge.
You were charged with driving while intoxicated. It is elevated to a Class A misdemeanor because of the high blow. We are going to do probable cause. Okay.
On May 23rd, in Harrison County, officer observed a vehicle on Guffman Hoppet curve while making a turn and almost striking a pedestrian. Officer conducted a traffic stop on the vehicle. Defendant was the driver and sole occupant and stated he had been drinking beers at a friend's house. Defendant said he had 6 Modelo's. SFSTs were conducted, 6 out of 6 HGN, 5 out of 8 walking turn, and 2 out of 4 one leg stand. DIC was read, and defendant provided a breath sample, 0.198 and 0.207.
Any prior DWIs, and does he have a
No prior
license?
DWIs, Judge, there's no license on record.
Okay, Mr. Rodriguez, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol or illegal drugs, and you will be tested. If I find that you're using, you will go to jail. You do not have a Texas driver license. You are not allowed to drive. I don't care what you have to do in this life. You will be signing a promise with me today. This is an affidavit that you're going to swear to us that you're not going to drive. If you do, you can be facing an additional 180 days in jail and a $500 fine every time you drive. Do you understand?
Yes, sir.
We are going to reset both of your cases to give you time to hire a lawyer. So each of you will come up, sign a reset. Both of you will take a seat while we have bond conditions created for you to sign. Once you sign, at that point, you'll be free to go. Do not pick up any new cases. Don't endanger my city, and don't violate these conditions. I will not warn you again. Do you understand?
Yes, sir.
Okay, come on.
Yeah, it's gonna fine. Señor Gallegos. Wait, insurance? Okay, la mano derecha. Ustedes van a informar que están en conducir en el estado de Texas. Sí, todo puede pasar con la señora con la camisa negra.
So on Castellano, did you file no going back?
And no engaging in any of the activities. They're filed.
I'm also going to do no weapons.
Luis. On page 3.
Mr. Chapman, you're charged with reckless driving. You're facing up to 30 days in jail and or a $200 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you soon.
On May 21st in Harris County, officer observed a motor vehicle on Highway 59 going 98 miles an hour in a 65-mile-an-hour zone, swerving in and out of traffic. Officer reached speeds of 115 in order to catch up to conduct a traffic stop. Defendant was then identified by his Texas driver's license.
All right, Mr. Chapman, I'm going to find that there's probable cause to go forward with your case. Do not engage in this type of activity again. Otherwise, I will revoke your bond and put you in jail. You understand? Does he have a license to drive?
Yes, Judge, it's helpful.
Okay, you're not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. You must maintain car insurance. Both of those are bond conditions. We will have them created for you to sign. Once you sign at that point, you'll be free to go. We're going to give you time to go hire a lawyer when you come back, have one. please.
Could you repeat the last part? I'm sorry.
We are going to reset your case to give you time to hire a lawyer. We have bond conditions created for you to sign. You promise us you're not going to drive in this manner again. Otherwise, it's just not going to go well for you.
Yes,
You
sir.
understand?
Thank you.
All right, come on.
Maybe. Chavesti,
Is it the bottom of page 3?
on page 3.
Chaveste? You are Mr. Chaveste. Sir, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On May 22nd, in Harris County, officer observed a motor vehicle run a stop sign. The traffic stop was then conducted. Officer smelled the odor of marijuana coming from the motor vehicle. The passenger, the defendant, leaned over and advised they were coming from their homeboy's house where they were smoking marijuana. Officer asked if any weapons were in the car, at which point both the defendant and the driver looked at the backpack of the defendant's feet on the floorboard. Officer searched the defendant's pockets and found a white and purple box labeled Pharmacran. Inside the box was 30 white bar-like pills, weighing 7.67 grams without packaging. Officer also recovered a firearm in the backpack.
So that's the PCS upstairs.
Yes, Judge.
Got it. Okay. And the backpack did belong to him.
I think check the R, Judge. It was seated between the defendant's feet.
Okay, yep, all right. Mr. Chavez, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using alcohol and drugs, including marijuana, you will go to jail. You are not to be in possession of any weapons. I'm going to test you 40 days from today. If you test positive for any kind of illegal substances, including marijuana, it's not going to go well between us. Do you understand? I have no problem putting your young butt in jail. And let me tell you, our jails are not a nice thing. You with your 100-pound butt get in jail, it's not going to go well for you. Get my hint? Don't violate these conditions. There's a co-defendant in this case, or no?
Yes, Judge.
You are not to hang out with the co-defendant in this case. You have the ability to hire a lawyer. How do you support yourself? What do you do with yourself these days?
I work in October,
And how old are you?
18.
Okay, you want to apply for a court-appointed lawyer? Okay, Deputy Williams will give you an application. Mr. Chavez, I don't know who you have in this life, but if I make your bond $20,000 to $40,000 and you don't have anyone to pony up that kind of money, you'll be stuck with me for a long time. Do you understand? All right.
Judge, if I may, I misread his name was listed twice. There's no co-defendant.
No co-defendant?
Yes, sir.
Okay, all right. Well,
Bowers, page 7.
good morning. Please.
It's Frank Bowers.
Yes,
For rain.
I got you.
He did line with 0.16 score, PAC.
Okay, Mr. Bowers, good morning, sir. Sir, you're charged with driving while intoxicated. It is elevated to a Class A misdemeanor because of the high blow. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Okay,
On May 24th, officer in Harris County around 2 in the morning observed the motor vehicle going 44 miles an hour in a 20-mile-an-hour zone. Traffic stop was conducted. The defendant, the driver, had red glossy eyes, slurred speech, and an odor of alcoholic beverage, and admitted to consuming 2 beers at a bar before driving. SFSTs were then conducted, 6 out of 6 HGN, 5 out of 8 walk and turn, and 2 out of 4 one-leg stand. The IC was read and the breath sample was obtained. .169 to .163.
Okay, no prior DWIs.
No, Judge, his license is eligible.
All right, Ms. Bowers, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using, I will revoke your bond and put you in jail. No more PR bonds for you. This is not a revolving door. Do you understand? All right, because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with them. If they tell me they cannot get a hold of you because you're ducking and dodging, then likewise a warrant issues. Don't pick up a new case and do not drive without liability insurance. All right, so we'll have you sign a reset. You'll get with conditions and then you guys are free to go.
I think he had a question about any travel restrictions. Do you have employment that takes you out of county?
I think my job is still right on the, it might be right outside Harris County, but
I mean, there's no travel restriction. At some point, you will get called to test. To go do it because it's a random testing. You just make sure you go test. If you don't, a bond violation report will be filed and then we're going to have issues. And that's just not a good thing. Do you understand? I mean, if there's significant travel, then we can talk about it. But I mean,
It doesn't sound like there is.
right. Okay, come on. Thanks. Hi, guys. Are you ready?
Yes, Judge.
Come on. Yes, ma'am.
Perching on Mr. Rugen.
With an R?
Yes.
You mind bringing him on?
My attorney's.
Have you filed an attorney of record yet?
Yes.
Okay.
Judge, there's no attorney signed on. You might want to fill out an attorney of record.
Yeah, I see a request for discovery.
We usually have them together in the single discovery with the first paragraph is.
Is that good enough to attach?
That's fine, yes.
You think so?
Mhm,
Yeah.
I'm looking through it right now. I'm not gonna revise.
So who's the attorney of record then? Okay,
Yeah, when it very time, it has to be a notice of appearance.
you still want a sheriff? Oh, no,
Yeah,
that's
she
you.
has to, because it doesn't say that she is,
Yeah, so if you don't mind, we have him on the tower just before you leave, if you don't mind filling out the notice of appearance.
absolutely.
Okay, good morning, Mr. Rugen. Sir, you're charged with driving while intoxicated. It is elevated to a Class A misdemeanor because of the high blow. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay,
On May 22nd, officer dispatched a suspicious person call. Caller advised that a male was knocking on the door and was not leaving the location. Officer arrived on scene and observed the defendant in front of the caller's home. Defendant had unsteady balance, glossy red eyes, and the odor of alcohol coming from his breath, and advised that he hit something and was asking for help. Officers observed a motor vehicle with damage to the front passenger side and tire, and the defendant admitted to operating the motor vehicle. SFSTs were then conducted, 2 out of 6 HGN, 6 out of 8 walk and turn, and 2 out of 4 one night stand. DIC was read, breath sample was taken, 0.167, 0.161.
okay, what was the stop?
There, so Judge, they responded on scene to a suspicious person's call outside of, it's a residential area. And then that's where they met the defendant outside the damaged motor vehicle. And he admitted to operating and they saw signs of intoxication.
Okay. Does he have any prior DWIs?
No, Judge, license is available.
All right, Mr. Rugen, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're consuming, including marijuana, I will revoke the bond, put you in jail. No more PR bonds for you. Do you understand? You are not allowed to drive unless you have a valid Texas driver license. You must also maintain liability insurance. If you don't have car insurance, then don't drive. That is also a condition. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with them. If they tell me they can't get a hold of you or you pick up a new case, I will revoke your bond. For now, we'll have you sign a reset. You'll get the conditions and then you're free to go. Please. Thanks, guys. Mr. Silverman,
How are you, Judge?
happy Friday, man.
Happy Friday to you.
What's
Have a
new?
new case on your docket?
Please, if you
Nancy
don't,
Davis?
okay, you mind bringing it up? Good morning, Ms. Davis. Ma'am, you're charged with just one, right? I've got two Davis. Okay. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay.
On May 22nd in Harris County, officer received a call from his sergeant regarding a motor vehicle that was swerving between lanes, and then the defendant had an odor of alcoholic beverage on scene. Upon arrival, officer also observed the defendant to have bloodshot, glossy eyes, and an odor of alcohol. SFSTs were conducted, 6 out of 6 HGN, 7 out of 8 walk and turn, and 3 out of 4 one leg stand. DIC was read and refused. Blood search warrant was executed and blood was drawn.
I already know what you're gonna say.
Yeah. 545.060.
That's really conclusory.
Yeah.
You know what I mean?
That's just from the DINs. I'm taking a look at the OR and all. This
Go-
is
I mean-
after the officer that was responding on scene to the sergeant's call out for a traffic stop. That's what it sounds like.
I need more than that.
I understand. I can take a look at the offense report to find out what he was called out.
Get on it, doggone it.
Yes, sir.
You can't see.
Good. No complaints. Great. You? Any vacations coming up?
You know, I'm trying to go to Japan at the end of July.
My in-laws were in Japan and they went to Korea and they said Japan was
It's
just
the bad.
as opposed to, Korea, just it just there's just no trash. It's clean. You can eat off the streets and they don't have trash cans everywhere. So people, if they have it, they just take it home and just.
And actually, the reason that started was there was like the sarin gas bomb thing that happened a long time ago where they were putting these bombs in trash cans. And so the Japanese just eliminated trash cans. So you have to carry your garbage with you. So we don't get like a convenience store. It's just people are a lot more socially conscious.
And imagine where what you try to do is you reinvent the things that are just so basic, like a toilet. When she was there, she was telling me how they have these toilets where
They're amazing.
there's like this dish where you literally wash your hands, right? And then that is used to actually flush the toilet.
It's
So you're
amazing.
so just efficient and safe. Anyways,
And for kids, so it's the best.
hey,
It's downloaded.
okay. Do you want to come back?
Sure.
You want
I
to
can do
wait?
that.
You tell me. Okay, just
No
come back and
problem.
then we'll give them more
No
time.
problem at all.
Yeah.
Thank you.
Okay, for sure.
David?
Just loaded there.
Yeah, we're gonna wait. Of course. Jed, it just loaded. If you want to come back real quick,
Yeah.
he's got it.
Yeah. Oh, I can hang out. He's got it down.
He's got it now. Yeah, come on.
Okay. Sure.
Anything new?
So deputies received a call around 2 a.m. regarding a motor vehicle swerve between main lanes. And then we observed prior to the arrival, officer observed the driver swerving when he conducted a traffic stop on the 2200 block of the Gulf Freeway.
Okay. All right. We're good. All right, I'll find no PC.
Thank you.
You take your client.
Okay. All right.
Okay, are you ready?
Yeah.
Yeah, no PC.
No.
Yeah.
Davis at the bottom of page 5 of the.
Coming up, man. Ma'am, you were charged with assault causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
I apologize for both. And
The other Miss Davis.
okay. On May 23rd, officer dispatched a disturbance weapon call. Complaining witness advised that she met the defendant 2 months ago and they were on a date at a club that night where they were drinking. After the club around 2 a.m., the defendant was upset regarding an incident at the club. A verbal altercation ensued, which became physical as the defendant struck the complainant multiple times in the face, scratching her body, and then choked her for about 20 seconds. Complainant advised that she briefly lost consciousness.
Oof. So this was an ex, is that what you said?
From the instructions, it sounds like they were still together.
Of the other, okay.
Yeah, the complainant and the defendant sounded like they were still together. They met and then they were together that night.
Do you think alcohol played a factor in this?
So there is an indication that they were drinking that day at the club before they came from the club.
Ms. Davis, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using, I will revoke your bond and put you in jail. You are not to have any contact with the complaining witness in this case and not to go back to this club. You understand the bond conditions. I'm not asking much, just don't violate these conditions. Otherwise, I will put you in jail. Do you have the ability to hire a lawyer? We will give you time. So I'm going to have you sign a reset. You're going to get with the bond conditions, and after that, you'll be free to go. Don't pick up any new cases. Don't endanger my city. You understand? Okay, come on. So which one of these Chapman ones do you want to sign?
One that's not fine because the.
Okay, so the one that says unsigned, I'm going to leave that one alone.
Yeah, I believe the state. There's like one person.
Well,
Oh.
all right. You were Mr. Dixon. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. I'm showing that he has a lawyer, actually. You have a lawyer, correct? You're expecting him here today?
Right here, okay.
Sorry? Okay, so we're going to wait for your lawyer to get here. If you just want to go ahead and take a seat.
There's somebody from that attorney on the docket.
It's all right. Don't worry about it. Not a big deal. Garcia Mendez? Oh, we did that one.
No, not that one. Mr. Nabuli is here and I texted.
Are you ready? Oh, but we need Luis, right? Okay.
Garza, on the bottom of 7.
Garza, come on up. No,
Garza.
not you. Lorena Garza.
Taking a plea, he'll be here in about.
Sure. Ms. Garza, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On May 22nd, around 10 o'clock at night, officer on patrol observed a motor vehicle speeding 71 miles an hour in a 60-mile-an-hour zone. A traffic stop was conducted. Officer observed the defendant, the driver, to have an odor of alcohol and glossy eyes, and the defendant admitted to drinking. SSPs were conducted. 4 out of 6 HGN, 3 out of 8 walk and turn, and 2 out of 4 one leg stand. DSU was read. The defendant consented to a blood sample.
Any project to be asked?
No judge. License is eligible.
Great. I am going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If I find that you're using, including marijuana, you will go to jail. Do you understand? You have the ability to hire a lawyer. We will give you time. You are not allowed to drive unless you have a valid license. You must also maintain liability insurance in your name. If you don't have car insurance, then do not drive. That is also a condition. For now, we'll have you sign a receipt. You'll get your bond conditions, and after that, you'll be free to go. Please.
Graham?
Mr. Graham, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On May 22nd at 12 in the morning, officer on patrol observed a vehicle traveling 66 in a 40-mile-an-hour zone and then run a red light. Traffic stop was conducted. Defendant driver was then detained and advised that there was a handgun inside a black backpack with the front passenger seat. Officer recovered the gun from the vehicle. While running a check on the firearm, officer observed a black wallet lying on the ground on the driver's side. And inside the wallet was a rolled dollar bill containing white powder cocaine, which is the PCS upstairs, Judge.
So stop was for, I mean, it's a good stop.
Yeah, 66 and a 40 and ran a red light.
Right. Why did it, what was justified to the search?
The driver failed to yield and enter the nearest parking lot, and then upon stopping, quickly opened the driver's side door, trying to exit. Which the
And?
officer thought was consistent with evading. So he was then detained when he exited the vehicle.
And then you just start searching?
The defendant advised that there was a handgun in the vehicle, inside the backpack. So that's when the search started after he was
I
told.
get it, but what, I mean, did he evade?
No, Judge.
Is he driving while black? Yeah. I'm not gonna, I'm finding no probable cause. Just take a seat. Did you start searching? I mean, really?
Right?
Yep, I understand.
Great.
I mean, he's free to go. I don't know if they're. Good morning, Ms. Green. Ma'am, you're charged with assault causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
In Harris County, complainant number one, Ms. McClure, advised that she is the defendant's grandmother. The defendant was living with her at the time of the incident in November of 2025. Complainant two advised that she was also at the residence and is a friend. Both complainants stated that the defendant became angry on November 22nd about a missing $5, and the defendant grabbed complainant one's arm, twisted it behind her back, and then pushed her to the ground. The defendant then drove away, but quickly returned and started striking complaining witness number two on her head with her fists, and then fled again. Both complainants advised they felt pain and were treated on site by HFU.
Over $5 freaking. Stop. Over $5. So they charged her with the injury to the elderly on the grandmother, right?
Yes, Judge.
And then what is the relation of the our complaining witness?
The other complaining witness, Judge, is just from what we have based on the den, it's just a friend.
Ms. Green, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to go back to this house and not to have any contact with the complaining witnesses in this case. If I put you in jail, which if you endanger my community, revoke any, or violate these conditions, I'm going to make your bond high. I have no problems making your bond 25, 50, 100, $250,000 in an effort to do anything to protect my community. Do you understand? I don't want you to put your hands on anyone. I don't want you to do anything that would break the law. Otherwise, I'm going to break the bond and it's not going to go well for you. You're not to be in possession of any weapons, no contact with complaining witnesses, no going back. You have the ability to hire a lawyer.
I already had a lawyer from the upstairs.
Just because you may have a felony lawyer doesn't, they don't come down here to represent you. You needed,
I haven't hired one because they're complaining to.
stop. I don't want to talk about the case. I only want to talk about the lawyer situation, whether you have the ability to hire one. Are you working at this time?
I don't go back to work till August. I'm a bus driver.
Okay. Deputy Williams will give you an application. I need you to fill out one to see whether you qualify for a court-appointed lawyer. Ms. Green, I don't know who you have in this life, but if I have to make your bond high and you don't have anyone to pony up that kind of money, you're going to be with me for a long time. It takes damn 9 months just to get 911 call for evidence. Do you understand?
Yes, sir.
All right, come on.
There's one in Juicy.
One what? Oh, I see what you mean. Okay.
Yeah, can I get you your signature?
All right, we're good. We're good. Yeah. Thanks, Ramon.
No conflict, no going back. no-
Yeah, right. Please. Talk to me.
There's no club room listed. I talked with the DAs and they can find it.
You said it was a club, right?
They went to a club, so I'm trying to find out what's going on.
Okay.
Yeah, that's what he said. They went to her house. So they have the club or the address.
Okay.
Okay, so just, I guess, put no bars, nightclubs, any establishment where 50% more alcohol sold. Yes, ma'am. Harris?
Yes, Judge Henry, at the bottom.
Mr. Harris, you are Mr. Harris.
Yes, sir.
Sir, you're charged with driving while intoxicated. You're facing up to a year in jail because of the high blow. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On May 24th, in Harris County, officer observed a vehicle on Brazos Street making several unsafe lane changes and operate with a defective right rear brake light. Traffic stop was conducted. Officer detected a strong odor of alcoholic beverage from inside the vehicle upon approaching. Officer observed the defendant to have glossy eyes and slurred speech and observed a red cup inside the center cup holder. Defendant grabbed the cup and lost control of it when the officer asked what was inside. SFSTs were conducted, 6 out of 6 HGN, 4 out of 8 walk and turn, and 2 out of 4 one-leg stand. DIC was read. Defendant provided a breath sample with the results of 0.152 and 0.148.
Any private UBIs?
No private judge license developed.
Mr. Harris, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, your order is not to drive any vehicle that's not equipped with an ignition interlock on it. If I find that you drive a vehicle that doesn't have an interlock, I will revoke your bond and put you in jail. You were ordered not to consume alcohol or illegal drugs, including marijuana. You will be tested. If you test positive for anything like that, then it's just not going to go well for you. Do you understand?
Yes, sir.
This is, stop. This is not, it's not a revolving door. These are conditions I'm placing on you. There's nothing that you can say at this time that's going to change anything.
Yes, sir. I just want to know what it interlock.
We'll get that. It's a device that you're going to put in your car so that we know that you're not going to consume alcohol and get into a car and drive.
Yes, sir.
Any car that you drive has to have an interlock. I don't care if it's your mother's car, your grandfather's car, or if it's a pony's car. If it is a car, it must have an interlock if you're going to drive. I send notice to DPS in Austin so that every police officer knows if they pull you over and that car doesn't have an interlock, they will arrest you. Do you understand?
Yes, sir.
All right. Do you have a lawyer, sir?
No, sir.
Do you have the ability to hire a lawyer?
Yes, sir.
We will give you time. I'm going to have you go to Ramona, sign a reset. You'll get your bond conditions, and after that, you'll be free to go. don't use. Do you understand?
Yes, sir.
Okay, come on. Come on up. Yes, sir.
Have Mr. Dixon on your docket.
Who is it?
Last name Dixon.
I think we already did it. Oh, no, we didn't. We waited for you.
Oh, fair.
Right, yeah.
We will waive PC if you allow.
Let me just, anything that we need to know, aggravating, does he have alcohol in the car, any prior DWIs, any maniacal driving?
Yeah, it's an assault, Judge.
Oh,
So
it's an assault. Oh, it's an assault. Right. Okay, sorry, I'd like to hear it.
Okay.
All right, sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. Okay,
on May 24th in Harris County, officer dispatched an assault weapon call at a residence. Complaining witness advised that she's the defendant's girlfriend for 3 years and they lived together. They were arguing that day. Things got physical and the defendant began to hit her with both hands using closed fists. Complainant advised she did not feel pain, and officer observed the complaint to have small lacerations on her chest and neck and inside her lower lip as well.
okay. Mr. Dix, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to have any contact with this person whatsoever. Do you understand? When I mean no contact, I mean no contact of any kind. Snapchat, phone calls, emails, text messages, use of third parties. I don't see him. Mr. Dixon. It did not, no. So I'm entering now what's called a mattress order for emergency protection. This is a court order that identifies Ms. Smith as a protected individual. You cannot commit family violence or an assault against this person and act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior, be in possession of a weapon, or go within 200 feet of where she lives or where she works. If you violate this court order, they can file additional charges against you, and a violation of a protective order is the capital murder of misdemeanors. Do you understand?
Yes.
Don't have any contact, don't pick up any new cases, and don't endanger my city. I'm not asking much from you. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with counsel. If they tell me they can't get a hold of you, then likewise, I will revoke your bond. For now, we will have you come up here, sign the order for protection. You'll sign a reset. We're going to have you take a seat while we'll get bond conditions. Once you sign them, at that point, you'll be free to go. Please.
Thank you, Judge.
So no contact, no weapons.
Yes, sir.
Do you have an arraignment? Doesn't know I'm having a contact.
Okay.
It does. We're good.
You see?
Yep.
Okay.
See, look at that paragraph. That paragraph at the bottom, that extra paragraph. That's the no contact portion. A lot of times, a lot of times they won't have any. So if you see that, then it means that they're splitting their. What's your last name, sir? Holmes. Holmes. All right. Good morning, Mr. Holmes. So you're charged with terroristic threat of a family or a household member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On May 22nd, complaining witness advised that her boyfriend and her had gotten into a verbal argument over the phone when the defendant stated that he would come to the house and shoot up the house. Complainant then called 911 and officers arrived on scene. While on scene, officers and complainant heard a single gunshot go off just north of the residence. Complaining witness immediately received a text from the defendant saying, "I won't miss next time." Defendant was then detained nearby and admitted to shooting the gun to get the complainant's attention.
Did they get the gun?
Yes, Judge.
Mr. Holmes, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to be in possession of any weapons whatsoever. If I find that you do, and I don't care what the hell the excuse is, you will go to jail and I'm going to make your bond high. You understand? You are not to have any contact with the complaining witness in this case. How old are you, sir? Do you want to apply for a court-appointed lawyer?
Yes.
Okay. Deputy Williams will give you an application. I don't know who you have in this life, Mr. Holmes, but if I make your bond $50,000, $100,000 because you're just a complete and utter danger, it takes damn near 9 months just to get a 911 call, and we wait until all the evidence is in. Do you understand? Don't endanger my city. No contact, no weapons, no.
No, sir. I don't have a client, I just wanted to, no client. I just want to say.
Come on. Hey, I'm live streaming, by the way, just so you know. Yes, absolutely. How are you? You look great.
You too. I watch you on YouTube.
I don't know. Hi, Dave.
Nice to meet you.
Nice to meet you. How are you?
Secretary of Law student in South Texas, so
You're in great
he's
hands.
working with, he's having.
So when I was a baby lawyer, I was with Albert all the time. It's a wealth of knowledge, and that's what you do as a baby lawyer. You kind of leech onto as many lawyers as you can to try to gain as much insight. You gain trial tactics, you gain knowledge, and then just form your own. But the idea is that you want to go, I mean, if you want to do criminal law, that is. So you want to go to as many different trials as you can. Look at all the big names. They all try cases all the time. So you need to go every time they try a case. You need to go to watch or die, take notes, and make your own style. I'm telling you, that's what I did. And man,
And so how you turned out.
I don't know about that, but everybody makes their own way somehow. But if you treat the law good, it pays back in dividends. I'll tell you, because no great professional. If you don't work, then don't work. Well, you're not making any money, but if you do well enough and you treat your clients great, it's there, really. So
He wants to start out in the DA's office and.
great idea, good. It's very wise because you want to get an idea of how they work cases, what they do, how the officers do things, how they think, why they do what they do. Then you get a better understanding. So when you do, if you eventually go here, then you're
Ahead of the game.
all the great lawyers do. Really. So it's a good idea. Yeah. Great to see you, Albert. And we'll have to get lunch one day. Yeah.
Wow. Continue watching on the YouTube. You can still send me inches of Oh my God.
I want to teach them. That's what I want to do. I was gonna reach out to someone to start. I wonder if there's like maybe some criminal.
You have such a big following, so.
Great to see Albert.
Good to meet you. Nice to meet you.
You too. Nice to meet you. Good luck. And you're welcome to come here anytime you want to hang out, watch, trials. You're always welcome. Well, just come hang out. You're welcome anytime. I don't do walkthroughs on any of those things. Yeah, but I'm not doing a walkthrough. What, Red, come on. bring it. I'm gonna need your help here momentarily. If just so you know, it's on Little. The case, we talked about it yesterday. Hold on, are you ready?
Yeah, I think so.
259,
Hold on,
18,
second.
59,
259.
1859.
Just be ready.
I will be ready.
Okay. Ramon Pineda. All right, Mr. Pineda, you are charged with driving while intoxicated. You speak English, correct? You're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Dude just had one dismissed not 2 months ago. Whoa. Where's Ramona? This attracts back to 15. Hold on a second. Ramona,
Yes, Judge.
I think this goes back to 15. He just had one dismissed 2 months ago.
Judge, it's 5 years from the date of booking. And on the other case, he was booked in. I talked to Victoria about it yesterday.
Oh, you did?
And, yes,
Okay. No, if you talk to Victoria, then she would know. Okay. All right, are you ready?
Yes, sir.
Go for it.
On May 21st, in Harris County, officer observed a motor vehicle going 97 and a 45. Traffic stop was conducted. Defendant, the driver, officer observed 3 Modelo beers, 1 half full, cold to the touch, in the middle console cup holder. Officer observed bloodshot eyes, slurred speech, and strong odor of alcohol, and the defendant admitted to consuming. Defendant admitted to consuming about 8 beers. SFSTs were conducted, 6 out of 6 HGN, 2 out of 8 walking turn, 3 out of 4 one leg stand. DIC was read and declined, and blood search warrant was executed with blood strong.
Mr. Pineda, does he have a license to drive?
There's not one on file.
You are not allowed to drive. You will be signing an affidavit with me today, Mr. Pineda. I don't give a rat's behind what you have to do in this life. If you drive, I can have a contempt hearing, and every time you drive, you can be facing 180 days in jail. You will get a scram monitor on your ankle, so I know that you're not consuming alcohol. If you do, you will go to jail, and I'm going to make your bond high. You just had a DWI dismissed. There's alleged, you said alcohol in the car.
Yes.
It's a minimum of 6 days flat. Any sentence that you get, if they prove at trial, there's an open container in the car. You understand? You are not to consume alcohol or illegal drugs. Can you run a full NCIC? Does he have anything else?
Yes, Judge.
We need guardian interlock paperwork filed so that DPS knows if he gets in a car and drives and they pick him up, that they'll put him in jail.
Judge, I'm seeing 6 cycles of information here, stuff going back to 2011, well, and then 2020. 2020 failed ID, 2020 DWI, 2021 failed ID, and then 2026 evading arrest with vehicles, and then 2026 DWI.
Do you think we should put any other conditions on him that have?
The airlock would be my biggest concern.
We are going to reset your case, Mr. Pineda, to go hire a lawyer. Don't use anything that has alcohol in it. Isopropyl alcohol, tequila lollipops, hair dyes, mouthwash. You understand?
So,
All right. He needs to. Yeah, yeah. And then, hey, and a scram.
Ryan,
Hey, how many more do we have? How many more do we have? Okay, I'm gonna help. Norm, I'll help you out next, so we don't have to wait. Let me finish this arraignment.
Oh,
No
that's
more.
fine. Good.
You are Mr. Ryan Brown.
Yes, sir.
Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Assault. Okay,
On May 24th, the Harris County officer responded to a family disturbance call. Complaining witness and the defendant have been in a dating relationship for 4 years and have 2 kids together. The complainant stated she attempted to show the defendant a video on her phone. He did not want to see it, began to mock her, calling her names, calling her lazy when she was making breakfast, and then threw a blueberry at the back of her head, stating the defendant was going to throw a hot pan at her. The complainant then sprayed the defendant with sink water. The defendant got angry, grabbed her by the back of her hair, back of her arm, causing pain. Complainant attempted to get the defendant to release her by throwing her arms at his face, smacking him in the face. Complainant slipped due to the wet floor, also grabbed his hair during the altercation. Defendant then took their 3-year-old from the residence while complainant took their infant and locked himself in the bathroom. Officer spoke with the defendant, who stated that complainant had punched him on the right side of the face. Defendant denied pulling complainant's hair. Officer also spoke with the witness, the complaining witness's mother, who was not there during the altercation, but did receive a call from the complainant where she stated she and the defendant got into an altercation with the defendant pulling her hair.
Mr. Ryan Brown, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to have any contact with this person whatsoever. You understand?
Yes, sir.
You have the right to remain silent, exercise that right. There's nothing that you can say at this point that's going to change anything. I have multiple DAs here. Whatever you say, they're just going to use to try to prove your guilt. It's just not worth it. At some point, you'll have a lawyer, and the lawyer can help you navigate through this. But I know you want to fight, just now's not the time. I'm going to do everything in my power to ensure that nothing else happens, no new cases. And so the conditions we place now are to ensure that nothing else happens in the future. So don't have any contact with this person. A protective order has been issued. You need to get to know the protective order. If you violate it, they can file additional cases against you, and a violation of protective order is one of the worst misdemeanor cases you can pick up. You understand? When I mean no contact, I don't care what your excuses. I don't care that you have children. I don't care that you have a pony with this person. I don't care that you've got clothes over there. No contact means no contact. Social media, phone calls, text messages, other people. You understand? You will have a lawyer, and the lawyer can come back and we can talk about things. But until this point, I don't know what she wants to do. I don't know whether she wants to have contact with you. So at this point, I'm ordering, stop. Don't say anything. I'm finding probable cause. Don't have contact with this person. You understand? We are going to reset your case to give you time to hire a lawyer. So for now, I'm going to have you go sign a reset. After that, I'm going to have you take a seat in the jury box while we get your bond conditions. Once you sign them, at that point, you'll be free to go. All right? Please. Okay, sure. Come on, Mr. Newley.
Come on.
Good morning, Mr. Newley. Happy Friday. Always. Always. All right, good morning, Mr. Garcia Mendez. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On May 23rd in Harris County, officer observed a motor vehicle with expired registration. Traffic stop was conducted around 11:50 at night. Officer observed strong odor of alcoholic beverage coming from the defendant, the driver, and the driver to have glossy, bloodshot eyes. Officer also observed a case of Corona in the back passenger floorboard with only 1 beer left in the 6-pack. Defendant advised he had 2 beers. A 12-ounce cold to the touch was found in the driver's front pocket of the door. SFSTs were then conducted. 6 out of 6 HGN, 7 out of 8 walk and turn, and 3 out of 4 one leg stand. DIC was read, fine, blood search warrant was executed, blood was drawn.
Mr. Garcia Mendez, I'm gonna venture a guess that it's damn elementary that you're not to have alcohol in the car while you're driving. And if it's proven at trial of an open container, it's a 6-day minimum. I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol or illegal drugs. Does he have a license to drive?
There's not a license on file, Judge.
You are not allowed to drive. You will be signing an affidavit with me today, promising me you're not going to drive. I don't care what you have to do in this life. Do not drive. You will get a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. If you find that you drive, I will put you in jail. You consume alcohol, likewise, you will go to jail. This is not a revolving door. If I have to put you in jail, no more PR bonds. I don't know what your immigration status is, but if you're not in this country with permission, you go to jail and immigration finds you, they may very well put a detainer on you. You understand? Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with Mr. Newling. If he tells me he cannot get a hold of you, then likewise, I will issue a warrant for your arrest. We will have you sign all the conditions. We'll have you promise us you're not going to drive. After that, we'll get you out of here. All right, thanks, Mr. Newling. All right, Norma, you ready? All right, come on. So I know, where is your client?
He's in the felony court. They said that if you want to get him in front of you, that you have to send a bailiff to get him if they set bond. And then they were just release him. And I've got John Burns here, but we're gonna end up going into custody because
That's right.
get a bond here.
Yes, that's right. And Norm, I can't treat you differently than I do
I'm not
anyone else.
asking you to treat
But
me.
I've never in 7.5 years done a walkthrough on a person who's has an MAJ because they picked up a felony case.
Judge.
I know that you may think it's not a big deal.
It's on video.
Okay, great. And let me tell you something. I had this conversation with your client when you guys were here last time, when I told him, yada, yada, yada. We had the same conversation and here we are yet again.
Well, okay, now,
But-
in this court, he's on probation for what?
An assault with that same complaint.
We have a violation for protected.
And,
Or it's a.
right, but the protective order was lifted, so he's not in violation. Felony court lifted its protective order. So your
He
court,
picked up a felony offense, Norm.
yeah, but the protective order had been lifted before that.
I see, so he's only, deferred on an assault family member that was reduced from a Berg had in felony court.
To this,
Those conditions reflect no contact whatsoever.
that was lifted.
Well, I see it on his MAJ that's pending now.
Yeah, there.
No, he's right. He's right. I remember. And the thing is Mr. Hyde, I brought this gentleman here last time. And this is quite possibly, I think the twice or third time we've had this exact same scenario where they're claiming that the complaining witness is just right. And so last time I sat him here and I had a 10-minute repertoire with him warning, you're a big boy. You know that you shouldn't get together with perhaps someone who, right? And here we are.
Judge,
Just picked up
here's the
another felony
deal.
case.
Okay, I've had thousands of these conversations with you. And this is, I'm not making excuses for it, but this woman is exceedingly manipulative. She has put 3 cases on 3 different men. The Webster Police Department told this defendant that if she tries to contact you, call us and we'll file on her for harassment. They know. So she's burned her bridges with the Webster Police Department. Now she calls the Houston Police Department. The patrol officers that respond close the case without making any arrests, without doing anything, because they watched the video that I have where the defendant is telling her to leave and she is refusing to leave. She's saying, I have to get my things. And so Then finally, they find her things that he puts them in a bag, hands them to her, and then she leaves. She is not injured. There's no violence on this video. There's just a woman being told to leave who eventually leaves. Then a week later, a detective, I guess, gets involved in this, and the woman goes to the hospital and so the state upstairs is like, well, now we have to get medical records. And so this is just ludicrous. And, this guy he's a fool. I mean, I can think of reasons to put him in jail or in timeout, but he doesn't need to sit in jail because of an assault or violation of a protective order. I mean, I can think of other reasons I'd like to sit in jail, but that's not one.
What is I don't know. I know that, Norm, I know that you have a side, but there's always two sides.
Sure.
So what happened and did they find probable cause?
He's charged with assault family member with a previous conviction. That previous conviction is the assault family member he's on deferred for in felony. The complainant had reported that her and the defendant were dating again. She was getting ready for bed. The defendant wanted to have sex with her. She refused to have sex with him. He got angry and he hit her several times with a closed fist, causing her pain. He then went to the hospital. The police spoke with the defendant.
Did she go to the hospital that day?
I believe she did. And then the police went and spoke with the defendant, who agreed that they were together. They got into an argument, but she just left. He didn't assault her.
So they found probable cause upstairs.
They didn't actually even rule on that. They just yelled at Mr. Little and said an $80,000 bond, $50,000 for the MHA and $30,000 for the new case.
Yeah, I don't see that felony court had found probable cause, but they at least signed the warrant. So imagine she reviewed it and found probable cause.
Yeah, Judge.
I'm not letting him do a walkthrough. I've never done it on an MHA. I'm sorry, Norm.
Well, just set a PR bond then. He's gonna make an
I'm not giving him a PR bond when he picked up a felony assault against the same
Judge,
complaining witness.
Legally.
I'm not allowed to.
There's no protective order in effect.
I'm not allowed to give him a
Judge.
PR bond on a VPO.
Judge, hear me out. The protective order that is the violation of a protective order in your court was no longer in effect. Legally, he cannot be guilty of that because the felony court.
I'm not arguing with you there about that.
Well, then what are we doing?
He picked up a felony assault against the same complaining witness.
Yes, this court has no case because he wasn't on a protective order when this happened, even assuming that he actually assaulted.
He's on probation. He's on
They set
deferred.
bond on that.
He's on deferred. One of the conditions are don't pick up any new cases, and you've picked up a felony assault.
Judge, he's on deferred for violating a protective order that wasn't in effect.
He
I mean,
pled
I'll
to
read
the.
it. That's.
You can. Oh, sure.
But it's like all we're doing is making someone sit in jail needlessly. Because there's no legal basis when the protective order was dissolved to be holding.
I don't understand what you're not getting about this. He's charged. He's on deferred. He picked up a felony assault. The fact that he's not on, there's no VPO has nothing to do with anything. He picked up a felony assault.
And just to trace it back, so the violation of protective order we had him for was actually a violation of bond conditions. The no contact bond condition that was on the felony offense that was later pled to the assault family member. I also hear you're both saying that the no contact is not in place in felony court, but
Now it is.
There was a no threatening or harassing
No.
contact.
It was-
Yes,
Yeah, no.
I said there was no threatening because I always do that.
Yes, you
on
did,
these
but
types
then
of
we
things.
modified it. There was first no contact.
Yes.
Then there was no threatening contact. Then there
Correct.
was removing all of it.
But that's
I didn't
only on-
remove all that.
Yes, you
Why would I
did.
remove that?
That's only on your case, right, Judge? Because on the
No,
felony
I
case.
Correct.
went to both courts and got it removed.
I don't know about
from both
upstairs.
courts.
I know about
Upstairs,
upstairs.
I don't see they ever removed it. I'm looking
If
at.
you'll
the-
call them, they will
Well, I'm
tell
looking
you.
at the.
I know,
paperwork.
they
In
look
the
at it.
MJ file, there's also.
Wait,
no contact
we're
violation.
going round and round over
Yeah.
something that doesn't even matter
Would you
though.
please call upstairs because they agree that it's not in the paperwork, but they also agree that it was removed.
It's
Please.
still on the MJ. And if, I mean, at this point, what do we address?
Well,
Is it bond amount? Are we getting him?
Judge, the man is gonna be on an $80,000 bond for some nonsense. That is more than sufficient to ensure his presence to answer.
If you want a bond reduction, I'm happy to give you a bond reduction, but I'm not giving him a PR bond and I'm not giving him a walkthrough. He picked up a felony assault
Just
against the
give
same
him a
complaining
standard,
witness.
I've got Mr. Barnes here to make any bond or reasonable bond the court sets. And I'm just asking.
What's reasonable in light of everything?
Well, I mean, Judge, actually, I know you said a $20,000 bond, the felony court put a $50,000 bond on their
Okay.
misdemeanor probation. I mean, I would
The
have
felony court
argued
just
50.
set $80,000 in bonds.
He's also, I mean, I see bond forfeited on his felony case, November of.
He's
2025.
he has a prior violation of a protective order. He's on deferred for a felony or for,
And this.
right, a bird hab that was reduced to an AFM. He's on deferred with us and he picks up a felony assault.
So just give him, he's on deferral, give him a bond.
He's on 2 defers and he picks up a felony assault.
Yes, if you'll settle.
And he has a prior VPO.
Judge, yes, and all involving the same person. He should never have pled the first case, but you understand why people make those decisions sometimes. But neither here nor there now. It is what it is. Would you please set a reasonable bond? He's entitled to one.
There is a bond that's set now,
What is it?
20,000.
Okay, would you reduce it to 5,000?
I'll reduce, what do you think?
Again, I would argue it's sufficient for that. I mean, the felony, which is a misdemeanor now, is 50,000. He's bond forfeited within the last year. He's picking up a new violent offense, felony offense. He's picked up several violation of court orders already. I mean, I believe 20,000.
Norm, I'll reduce it to 10,003. Okay, I'll cut it in half.
Okay.
But in light of the fact that, let me ask you this, he has a prior terroristic threat, same complaining witness?
Different person. And that case was a Class A terroristic threat involving someone he had a dating relationship with.
That was in what year?
That was from.
Yeah, that's old, that's old.
But he was convicted. Which gave him the affirmative finding. One of the affirmative findings, he now has 2.
Okay, I've reduced it to 10,003. Okay, okay, man. Hold on, I have 3 more arraignments to do. Let's,
Toronto, Judge, on page 18. Toronto.
good morning, Mr. Serrano. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On May 23rd in Harris County, officer dispatched with a family disturbance call. Complaining witness, the defendant's girlfriend, stated the defendant was demanding $30 from the complainant by compelling and cursing at her. Defendant's sister told the defendant to stop calling her a bitch. Defendant became upset, balled his fists and went to her face and told her not to interfere in his relationship. Witness stated defendant is very aggressive and was drinking alcohol that day. Defendant's sister told defendant she was going to call 911, went outside. Defendant's sister then went inside after calling 911 and stated that her mother, the witness, told her she saw defendant pull complainant's hand after defendant's sister went outside. Complainant stated she was asked by the defendant to borrow money, told defendant she does not work, does not have money, or gas for their vehicle. At that point, the defendant pulled her hair, causing pain.
Got it. Ramona. You need to talk.
Brian Brown.
Mrs. Serrano, I'm going to find that there's probable cause to go forward with your case as a condition of your bond. You're ordered not to consume I'm sorry, not to have any contact with the complaining witness in this case and not to be in possession of any weapons. You understand your bond conditions? Do you have the ability to hire a lawyer?
No,
How are you supporting yourself?
I was doing laundry, but no one did not help me.
Why not?
My machines broke down, so I haven't been able to do anything. And I've been applying for a job, but my license was expired. And I had traffic tickets, so I couldn't go through the DPS to get it.
Then find something close to your house, but it's time for you to start working. I'm going to make that a condition and I'm bringing you back in 2 weeks to see what you have done to get a job. If you've done nothing, it's not going to go well between us. Do you understand? When you have too much time on your hands, people tend to become self-destructive. You need something to occupy your time with. Otherwise, you understand.
Yeah,
We will give you an application for a court-appointed lawyer. Do not have contact with this person.
I understand.
There's a protective order that has been issued and you need to get to know it. If you violate the protective order, they will file additional case, or they can file additional cases against you.
Yes,
You understand?
yes, sir.
All right, Deputy Williams will give you an application. We'll have you sign. All right, ready?
Here we go.
Oh, no, hold on. No, I got two more rings. Sorry. Oh.
No?
Thank you,
Please,
Judge.
sorry about that.
No, no problem at all.
Okay, do you want Brian bringing up your client? Let me make sure I hear. Hey, Mr. Hyde, can talk, stay here. All right, sorry, what's the last name?
No, no.
And Jim, all right, good morning, Mr. No.
Good morning.
Mr. No, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. All right.
On May 22nd, officers in Harris County dispatched to a male asleep behind the wheel with the engine on. Officer on scene observed the motor vehicle with the engine on and defendant having mild odor of alcoholic beverage, glossy eyes, and slurred speech. Defendant also admits to consuming alcohol. SFSTs were conducted on scene. 4 out of 6 HGN, 2 out of 8 walk and turn, 1 out of 4 one-leg stand. DSC was read. Breath sample was obtained and results were 0.14, 0.14.
What was the stop again? I missed it.
They were dispatched to a male asleep behind the wheel with the engine on.
Got it. Where was he?
Was 303 Memorial City Way.
It matters.
Yes, Judge. Looks like a mall, Judge. Cinemark Memorial City.
Great. Where is he?
I'm sorry.
Where? Is he in the middle of the street? Is he in the parking lot? What, I mean,
So Judge, from the dims, he was in the, looks like the parking lot.
did anyone see him driving?
Just that he was asleep with the motor vehicle on.
Great. How do you know he wasn't drinking in the mall and just came home and went back to the car and slept it off?
Understand, Judge? I do
Did anyone
think
see him
there's-
driving?
I do think that, Judge, the operation could be there with the engine on and him in the driver's seat and in case.
No, it gets hot as get out in Houston, right?
I understand,
I mean,
Judge.
you sit in a car
It's
with
also-
no,
It's also 10:30 at night on the day. So
I get it. I don't know if it's enough, man. I need something where you're showing he's driving somehow.
okay, so operation is concerned,
Yeah.
so
How do we know he didn't go to a bar inside the mall, get loaded, and then just come back and sleep in his car without driving? How do you know that?
I do think, Judge, that the argument will be made that operation doesn't necessarily mean that he's driving around, but that the engine's on, he's in the seat.
This is a criminal case, man. We don't operate on hunches. This is someone's life, you know? Really. Unless you can show me more. Is that it? All right, I'm gonna find no probable cause. Mr. No, be careful, man. Really, every day someone dies from a DWI account. All right, please.
Thank you, Your Honor.
Okay, of course.
519 Stewart.
Darius Dixon.
You're not.
Is this the last one?
No, we have one more.
Okay, Mr. Stewart, you're charged with driving while your license is suspended or invalid. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
On May 22nd, officer conducted a traffic stop on a motor vehicle for expired registration. The defendant driver did not have a driver's license, but presented an identification card and was found to have 6 outstanding custody points. License is currently not eligible as well, Judge.
Mr. Stewart, you are not allowed to drive. You do not have a valid Texas driver license and presumably insurance as well. You must have both if you want to drive at all. It is a condition of your bond that you're not to drive at all. Do you understand? You will be signing an affidavit with me today. This is a promise that you're going to make to me that you're not going to drive. I don't care what you have to do in this life. If you go get your license, go get insurance, show it to me. I'll happily take this off. But until that point, you drive. It's just not going to go well for you. Do you understand? You have the ability to hire a lawyer. How do you support yourself? Do you want to apply for a court-appointed lawyer? Okay. So what I'm going to have you do is I'm going to have you come up here, swear to us that you're not going to drive. I'm going to have you take a seat while we get all the bond conditions for you. After that, we'll reset your case, give you time to hire a lawyer. Okay? All right. All right. Last one. Bring it.
No driving today.
Government 23, right?
Yeah, just no driving. Did you say Ray?
Right. Bottom one, 23.
Good morning, Ms. Wright. Ma'am, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On May 1st, officer dispatched to a disturbance at Walmart. Complaining witness observed the defendant scanned multiple items using a tumbler barcode and then pass all points of sale with no attempts to correctly purchase the other merchandise. Valued at $152.65.
Did you say she used a device?
She used a tumbler cup, a different cup, and then walked out with other items. Scanned one, walked out the rest.
Ms. Wright, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to go to any Walmart for any reason whatsoever. If you do, I will revoke your bond, put you in jail. If you pick up a new case, likewise, I will put you in jail. No more PR bonds for you. Do you understand? Do you have the ability to hire a lawyer, ma'am? I'm going to have Deputy Williams. Let me see if I have. Did you want to apply for a court-appointed lawyer? Okay. I already have one. I'm going to have you you'll have to sign a reset. I'm going to have you take your seat in jury box. We'll have bond conditions created for you to sign. Once you sign them, we'll try to find your lawyer. Please.
Castellano,
So no go ahead.
Yes, sir.
Okay.
Already filed.
Okay. Are you ready?
Hi.
Yes. I'm ready to set these cases for trial. It's just way too much drama for me. Unless we're doing something.
Well, we haven't won it. The last time we were here, you said you wanted him to do a T-route, but you didn't consider.
Yeah, I think that's right. I think that's a good idea. So I'm going to order as a condition of his bond now that he gets a T-Raz done today. And then all the same. Oh, that's right. Damn. Yeah, we'll have to do it Monday. They're not doing any walkthroughs today. So I'm gonna order him to do the TRAS Monday.
Okay.
All the same conditions will continue. Mr. Watson, come up. You are now on what's probably your fifth or sixth bond violation. If you violate conditions again, and I don't care what it is, I don't care how minute you may think it is. If you violate conditions again, I'm going to multiply the bonds by several zeros. You understand? You have 4 open cases. You violated conditions at least 6, 7 times. I'm going to go bananas on your bond if you violate again. We are now sending you to get a TRAS done on Monday. Then I'm going to have you come back the next 4 days, and we're going to decide what we do with this case. I'm fast tracking it to trial. It's way too much drama for me. Do you understand? You were ordered to be here Monday to get a TRAS done. And then at that point, we'll wait, 3 or 4 days. As soon as we get it, we'll notify you, and then we'll figure out how to go forward. All right? Come on. Thanks.
May I excuse?
Yes, ma'am.
Judge, you want me to come down and-
Yeah.
Okay.
Hi, are you ready? Good morning.
Okay, so, Christopher G, we've been on the docket, we on Wednesday, came back to home today.
Great.
You got yet another technical issue with getting the bond condition signed by PDF and email.
What? So let's just print it out and have him sign it like,
Well, like, it was, yeah, it's
Okay.
done now, yeah.
Okay.
So I just wanted to let the court know that Mr. Chairman.
so we'll reset your case. We'll waive the appearance. Just tell him to stay in contact.
And he did inform me this morning that he did have contact with the complaining witness and scheduled for court. However,
I don't even remember what he said.
It was, she contacted him, this is a case about a broken phone. She contacted, it's criminal district.
Sure.
She contacted him to tell him what the cost of replacing the phone was.
Mr. Jean, come up.
I already told him that it's a two-way street. Even if she contacts you.
I'm going to admonish him now, but do you know if she contacted him or he contacted her?
I do not have any information on that. I was just told by the.
Do you mind reaching out to the complaining witness today and asking them, telling her not to have any contact with him? Please.
Yes, sir.
You are not to have any contact with the complaining witness. I don't care who initiates contact. I wasn't here when I placed the bond conditions on you. Otherwise, I would have told you that because I tell that to every single person. Contact means no contact, phone calls, text messages, social media. Even if she contacts you, comes to your house, don't answer the door. If she texts you, do not reply. If she calls you, hang up. It can be easily proven in the age of this technology whether you're having contact with this person. So just don't. It's not worth it. I don't want to have to put you in jail. I'm not asking much from you. You understand? Just don't have contact with the person. Do not pick up any new cases. That's it. And stay in contact with me. That's all. Right? Okay. So we'll just have you sign. He's been admonished. All right. Okay. Good luck, Mr. Jean. All right. Thanks. Hi, Adam. Come on. Good morning, Mr. Kim.
This is the correct Bernard Lane,
Oh, okay.
clause number 2620652.
So it's not on docket today.
No, it's not.
Okay.
So he was originally wanted out of Elmore County, Idaho for, it's very long, but it's at least 20 some odd charges of various theft, burglary, etc. I messed up on the pickup date because it was originally reset out for the 4th, the 5th, but it should have been the 8th because of when he was released from our local Harrison.
You asked for a 3-day extension last time, did you not? Or is this a different one?
This is a different one. They've
Okay.
never asked for an extension. So the reason why I'm pointing out, I miscalculated the date, because the original correct pickup date would have been the 8th. And the demanding jurisdiction is asking for a 3-day extension from that because, and this is what they originally asked a week, but if I can make my argument.
Sure.
So from the 8th, the 11th, they literally have their finger over, hovering over the flight. The deputy took his birthday off just to get your decision so that they can come on the morning of 11th, because I knew you want to give the 4th day. And so on the 3rd day, on that morning, they're coordinating with our sheriff's office just so they can make the date. And now because he seemed inclined to decline, I'll list out the charges. He's wanted for theft scheme, 1.5K to $25,000, 4 burglary, 2 counts of theft, 4 counts of burglary with tools, 6 counts of theft, 5 counts of rogue and vagabonds, 3 counts of.
All these are open right now?
Yes, and I opened that 1 count. I'm not done. This is 2 counts of another MBOP and 2 counts of continuing theft to 1.5K. And that's just Elmore County. If I run his FBI number, I can list out all the other charges. It's obviously.
That are open?
That are open in Elmore County.
So how many are you saying?
19, 21, 23, 23 charges out of Elmore County. So that's why.
Can I have the cost number again? I missed it.
262-0652. And just a bunch of back and forth with the deputy there because I told him like, I'll ask for it, but I know you want to give a week. That's why we're pushing it to give the 3rd day on the morning of the 3rd day to pick them up from the holdover. Because I knew you want to give the 4th.
They've had 2 weeks to come.
And this is.
Well, they got the date was wrong because of.
That's my mess up. And for what it's worth, he has a previous case in 2023, so this isn't the first time he's run a whole.
I see it's a 3rd, huh?
For the,
It's a 3rd fugitive case.
oh, third, I just put previous future case.
So you're saying that 4th day then, right?
Right, I'm saying because because they're picking up on the 11th, typically I would ask for the 12th, but I knew you wouldn't go to the 4th day, which is why.
Okay, all right. Okay.
The 11th.
I mean, considering he's got 16 open charges, I mean.
It's not great. No.
Okay.
Okay.
Thanks, Adam.
Oh.
I know.
I mean, Judge, I would also, I would just note, so they did sign the waiver on the 19th, so,
20th.
the 20th.
If they don't come on that day, I'm gonna give them a PR bond on 16 cases.
Okay.
So just notify them. I don't care.
I
mean, I don't.
And I'll make sure that it's coordinated with our sheriff's office.
Okay. Good morning, Mr. Reingold.
Good morning.
You ready? Yes, ma'am.
I have Mr. Church, I saw this unlock it, it's like maybe ours.
Where's Mr. Terrazas now?
He's in the jury.
You have him come up, please.
Information on the side.
You really want to go to jail, huh? You're begging for it. Stop. You were begging. I ordered you not to use. I gave you a device and you have 10 skipped tests. You were begging to go into custody. And with your history being that you have an intoxication manslaughter, not, or intoxication assault, 2 years ago, you will get a scram device on your ankle now, Mr. Terrazas. And let me give you a little perspective. This now, I have nothing further available other than jail to curb any other behavior. This is my last ditch effort to not put you in jail. You hold the keys, and with your history and the amount it is, if I put you in jail, you're going to get it's not going to go well for you. Do you catch my drift?
Yes, sir.
Okay, any further, it's no tolerance now. Any further violations? That's it. I have nothing left at my disposal after this point. All right, thanks. Hey, send him for a drug test too, please. Thanks. Okay, Norm, you ready? Terrazas.
I just wanted to have the clerk set, or the coordinator set a future date.
I can't if it's an open warrant status. You have to set it, you have to either make the bond first, or we have to take him into custody.
Okay, when you go to make a bond, they want a future date. He's got a felony for a future date. I just want to put the misdemeanor on the same day.
It's an open warrant status. I can't do that. He has to make bond first, or he has to go into custody. I can't do that.
How did the felony for?
Because they may have given him a PR bond, they may
No,
have done,
no,
or they let him do a walkthrough. I have no idea.
I'm not trying to walk him through. I'm just trying to get the same future date so that he can be on the docket the same day.
What day do you want?
June 25th.
You can have, sure.
Okay, that's all I'm asking.
Yeah, but he needs to make the bond and then we'll give you that date.
His father went burned. They're gonna go sit out for many hours and then he'll be released.
Okay,
Yeah, I'm
Yeah.
not trying to trick anyone.
I understand,
I'm
I
just trying
understand,
to
but,
put
but
it on the
understand
day
that.
when I'll be here.
So we will give you the date once they get that date, because when you make a bond, you get a 7-day setting.
Right, which I'm not gonna be here. So I'm trying to-
Right, of course. And once we get notice of that 7-day setting, whatever that date is, then we'll give you that date. Yes, of course you can have it, but I still need him to make the bond first so we can get that date to be able to change it. If it's an open warrant status, I can't change anything now.
No, it used to be the exact opposite. If you didn't have the future date set, they wouldn't let you out of jail. You had to go. So I guess they changed.
I don't know now, because it shows open warrant status,
Yeah.
it's basically bond denied until you do something about it, which is
Okay.
either you go in and we process you in, or you post a bond when you get that 7-day setting at that point. So, I guess I'll just have them be on the lookout. He'll
Okay.
make bond today.
Yeah.
At probably within the next 8 to 10 hours. It's gonna be after hours. I don't know how. So, but he wants to give us the date now, so he has it, so that when the bond is posted, we can put it for that June, whatever date. that- But also, Norm, I have to do bond conditions on him too.
Oh.
So I'm gonna need him to do bond conditions. You can always zoom in. I have Zoom for you. You can, wherever you are in California, Abu Dhabi, you can always zoom in, and I'm happy to have you via Zoom, so you don't have to be here physically. He has to be here to get bond conditions and at least sign it, and then after that, we'll waive the appearance. But at least I need him just for the first setting, and then after that,
Okay,
you can always appear via Zoom, so you don't have to be here.
okay, thank you.
Okay,
All right.
so just, if you don't mind giving it to Ramona the date,
Yeah,
and then I guess we'll just be on the lookout, and when we hear of what that 7-day setting is, or at least tell John to let us know,
yeah,
and then we'll change it for you.
okay.
Yeah, okay, for sure. So, Norm, I guess, do you want to bring him in on Monday then? And then you appear,
I mean,
I have to do bond
I can
conditions.
send you that photo.
Or you zoom in? If you want to send someone, great, but tell him,
I told him, so I'm moving.
but but I need to have him sign it so that if he starts mucking up, I can do something about it. You telling him, I have no power to do anything.
She's very, too frustrating.
So you want to have him just let him know to come here Monday
Okay.
after he's posted bond. We'll do conditions Monday, and at that point, we'll give him whatever date that you want.
Okay.
What day did you
June
say?
25th.
June 25th. Okay,
Thank you.
for the,
Right.
okay, I got you. I'm gonna send you an email now,
Okay.
and I'm gonna attach the states so that we're all set pursuant to our conversation. Defendant is ordered to be here Monday,
Monday.
June 1st.
Right.
A counsel can appear via Zoom or have someone else, and then we'll just do bond conditions, give him the date that you want, and then,
Okay.
okay, thanks, Norm. Okay, you ready? Hi.
Okay, so I had kind of a little fiasco yesterday, but I'm up to speed on it today. My
Don't-
client, Adriana Hernandez, was on
Correct.
camera for 4 days. I told her she didn't have to come, but that was,
Is she here now?
yeah, she is.
Okay.
I've got her here.
Hernandez, come up,
I got it right outside, let me grab it.
please. Mr. Davidson, did you want to talk while we're waiting?
I've got two, cases to approach on, and they're a little bit complicated, so.
Okay, I'll wait.
I don't want to get in the middle of.
No problem.
Just get the calls over Hernandez.
I don't. We're gonna have to get it. But it was the bond revocation from yesterday because she didn't appear.
Okay. Let's see if I can pull up that.
What's your cause number, please?
It
Sorry.
is 25-91125.
2591125.
25-91125.
I put too many one. Here we go. Ms. Hernandez, I want to give you a little perspective. Your case is extremely old. We set cases for trial at 180 days. Your case is near at like 300, right? You need to make a decision on what you want to do. You must either accept a plea bargain agreement, set this case for trial, or do the PTI program. If you wanted to do the PTI program, you need to have everything done by next week, by the end of next week. It's sufficient amount of time for you to get, is she approved? I mean, or does she need a mitigation package? You will need to do a mitigation packet. I'm going to let her explain that to you. If you have everything done by next week, we need you to turn it in. And then at that point, we're going to send you for a walk through TRAS, which is something that everybody has to have everything done. If you don't have it done by next week, you must either accept a plea bargain agreement or I'm setting your case for trial. But that is the last reset. I'm going to reinstate your bond today. If you ever miss court again, it's not going to happen again. Do you understand? Okay. So just pick whatever day you want next week and then we're good.
Okay, thank
All
you.
right. Yes, ma'am.
Thank you very much.
Same thing, right? It's a DWI. So all the same conditions that were there beforehand. Did you guys?
Yes, sure. See.
And then use a little 10,000 things. I'm doing the bail order on it, just so, okay. Okay, all right, you ready? Thanks for being patient.
So first case is, on today's docket, it's rather old, speaking of old cases, is Estella Suarez.
Suarez.
There's a DWI charge and assault damage. They're both dated in 2021. And
Is she in jail or on bond?
she is in jail. She was made bond on the DWI, it's out of the top family members. And,
Whoa!
Yeah. Sometime in mid-2022, she entered a rehab facility and tells me she has been sober since that time. And that part of her absence from court was due to her, excessive drinking. But, I don't have any verification of that. That's just what I learned.
What would you like?
I don't know. I mean, she's 50 years old. She made bond on one case. The bond on the assault family member is less, actually.
How did we, maybe, did they give her, it's an $8,000 bond. I mean, did they give her a PR bond? Do you mind? I don't see in the system. Suarez. Her bond was surrendered and, the paperwork has probably not been imaged yet because it's been so soon. So that's why, I don't know, maybe they can see.
Right now, I see Sherry was the boss, so I
Really? She made an 8,000?
That's right.
Yeah.
She has a Sherry.
Huh. But she didn't make it on the second case.
Apparently not, and I don't know what the explanation for that is at this point, but in any event. We could, in theory, roll her until Monday, because I will be back.
Sure, of course. I'm happy to do whatever you want to do. So, but does she have a license to drive?
She hasn't listed it, but I'll run it right now.
Okay, so, but the bond conditions will be no alcohol, no dope. It's a second, so guardian interlock. On the AFM, just no contact, no weapons, and then, so it's relatively old, so if she does bond out, she's gonna get a GPS monitor because she's been gone for so long.
Yeah.
And then we'll give you 30 days to figure out what you guys want to do. Do you mind putting an offer on both cases now? Or, I mean, between now and the next setting, is discovery complete?
No, none of the data.
Get on it,
Yes, Judge.
because I'm telling you now, I'm not gonna wait. I don't care if you have it or not. It's 1900 days old. Just, okay?
Oldest case I think I've had in a long time.
It's pretty old. Okay, who's number two? So Monday on that.
Next,
Okay.
please, another case on today's docket. I believe it's the first setting, it's a Marion Holmes.
This jail or bond?
Bond case, terrorist threat. And there is there appears to be a MOAB in regards to the complaining witness in the line of Wheeler. What Mr. Holmes wanted to inform the court is that Miss Wheeler is pregnant with his child, apparently.
This is the one where he shot the gun, right?
Right.
He allegedly shoots a gun. The next time says, hey, man, next time.
I won't miss. Yeah.
It's,
Behaving badly for sure.
well,
He is-
at least for the time being, cool off, number one. Number two, I don't know what she wants. Maybe she doesn't even want to have contact with him. So
Perhaps.
before we do that, I'd like to know what she wants. So let them do a rip. We can come back maybe next week and then let's see what she wants to do and then we can redo it. But for the time being,
Right, it was,
Pretty-
until once I discovered he was firearm mixed up in all this, I thought, well, probably not going to be able to. deal with
It's
that. He
kind of
wanted to have-
scary.
He wanted to be able to visit the child.
there's no problem. So Mr. Holmes, come up. I will tell you that 90% of the people that we have in jail now are there because one reason and one reason only. You want to care to take a guess why? No, why are they in jail? Why do they get charged with a crime? Why? Take a guess why. Self-control. What happens is they get upset, wig out, and do whatever they want to do without thinking, if I do this, what's going to happen? If I say this, what's going to happen? Without thinking, geez, if I do this, if I kill this person, I'm going to be locked up for the next 70 years. They don't think about consequence. 99% of the people that are in jail are there. No self-control. The idea is that there is a cooling off period now. And if you have a young child, Mr. Holmes, the apple never falls far from the tree. So if you, at the young age now, become someone who is in and out of custody, in and out of problems with the law, the apple doesn't fall far and your kid will be exactly like you. That's great that you want to be with your kid, but if you do, be the right person for the kid, not someone who's in and out, because they're, I promise you, you may not believe me now, but the kid looks up to you, will want to emulate you, will want to be you. And if they see that you go in and out of jail, they're going to have the mindset, well, it's okay. My dad did it. Do you understand? I'm not telling you that you can't see your kid. I just don't want you to have any contact with this person. If you have a family member, if you've got a friend that can go, help you with the exchange, great. Don't have contact with this person. I don't care if she reaches out to you. If she reaches out to you and you have contact with her, we're going to have issues. Do you understand? No social media, phone calls, text messages, anything of this nature. I'm not asking much from you. All I want is you not to pick up any further cases. That's the goal here. And to end up in a better situation than when you left. Do you understand?
Yes, Your Honor.
Once you sign the conditions, you guys are free to go. Time heals all wounds. After some time, we can come back. We can maybe revisit things, but for the time being, really, if you have a gun, you got a weapon, I'm going to go bananas. Do you understand?
Yes, Your Honor.
Okay, weapons to tap into.
Sure, but people are crafty nowadays. So forewarned is fair warned.
Buying weapons.
Okay. All right, guys.
Okay, that's all I have to do.
Good luck. Thanks. Have a great weekend.
Hang on.
Hi, you ready? Come on.
GAML.
And
Good news.
what?
We had 2 negative tests.
Mr. Come on. Great job, man. Really. One day at a time, that's all it takes. I know it's hard, it sucks. I know. Just one day at a time, that's all it takes, you know? At some point, you're gonna get frustrated, you're gonna get angry, you're gonna start thinking, just take the right steps. Don't fall into the trap. It's one thing and one thing only. It's mind over matter. Your brain is strong enough to overcome it. Don't miss any more tests because we always think the worst when you miss a test, and that's why you're here now, okay? All right, we'll continue supervision and then just don't miss any more, okay? All right, guys, thanks.
Well, use your attention. That's 100.
Hey, good morning. How are you? Happy Friday?
Happy Friday.
Who you got?
Approaching on a old problem that you and I discussed.
I remember this, the license issue.
Awesome, yeah, so.
Did you figure it
The
out?
underlying case, before your court's been dismissed, I'll send the admission interlock removal order under the proper license. So that's all done, but unfortunately, they still haven't taken action and corrected the initial form. And in fact, they've sent me correspondence back.
What the hell? Have you spoken to Mr. Hyde?
I called.
I don't know what you judge. I haven't heard.
Oh, you don't know, you don't know.
Well, I just mentioned it.
Okay,
Richard Juris was the one I talked to last time.
sure, I remember. Yeah, he's gone.
So they did send me correspondence back through the mail, and interestingly enough, it was addressed to me and the court clerk, so I don't know.
Huh.
So I thought I
Weird.
would bring it to your attention. I
I,
can even make an.
can I see it?
Absolutely.
This is a weird situation
It's very.
where we have a defendant. Do they have the same birth date or no?
Different dates of birth?
So it's, the defendant has the same name as another one.
Okay.
One picks up a DWI. And they issue was it a suspension or the interlock requirement
Interlock requirement.
on his client, which is not the right defendant?
I guess attached to his GL number.
Well, interestingly enough, if you look through the data and the district clerks, it's internally inconsistent. At one point, it has the proper date of birth, and then other parts, they pick up the wrong date of birth. So
Regardless, his client, is it, he can't get the license back? Is that what it is?
it's canceled pending a fix. And yeah, so right now, if he drives, I have all the correspondence, say, look, you know. But I'm sort of advising not to. And it's
What would you like?
understanding.
What would you like?
The court in that letter, I think, has suggested a DPS correction form, which I think your clerks either have or have access to through DPS.
We do.
And I even talked to, I called the number on them, which I think was submit for your clerks, and they're like, hey.
I'm happy to do whatever you need to do. Just
And I'm
let,
happy
just
to
if you want to let
cooperate
them
with
know, just let them know and then we'll, DPS just can't. It's just, this poor guy's been trying to get his license for now, is this going on 2 years now?
Not quite that long.
But,
A lot.
and they've been going back and forth and back and forth and they just,
So they need a break.
That's the only.
The other guy picked up the data, but they just put the interlock requirement on his client. But his client never had a before. And so did we do an interlock removal order for
What we
them?
did, well, two things. First, we did an amended ignition interlock form requirement, which y'all, and I gave me a certified, I said, look, your officer of the board, send it to him, and get it.
But we also send that too, though.
I don't think they received it, though. I don't know if that has.
So let's do it
with the
again.
way-
Let's do it again.
When I called enforcement compliance and they say, you didn't get it, and I know that y'all actually substituted the amended order, because when you go through the district, the history and images, the amended order is the only one there.
So if you just give them the information, we can do it again. And,
Absolutely.
you know, maybe in 2 weeks, call them to make sure that they've received it. If not, we'll just keep doing it. Right, so you trying to send them something, it's gotta come from us. So, yeah, whatever you need, we're happy to give you. Just ask and then we'll,
Well, thank you.
yeah, of course. Sorry about the problem. That sucks. Mr. Butler,
Yes.
what happened? You're back. You didn't need to come back.
Well, I know, but, I think-
Really? And I have Zoom, so you don't even have to come.
Okay, well, I'm here anyway, so.
Okay.
My surgical computer next one.
Oh, okay.
This Friday. So Mr. Mendez is here. And he is,
Oh, that's why you're here.
yeah, and he is also begging me to allow him to use his mouthwash. It's a necessary part of his treatment.
There's got to be another way, you know? Hey, Mr. Hyde, from yesterday.
Yes.
Sure, I get it.
I don't know enough about scrams, but I mean, would a scram device make it better?
He's got one, but the problem is he's going to consistently test for positive. We'll never know if he's consuming alcohol.
I don't think that, I don't think there's gonna be an issue there, because he's not drinking it, he's just rinsing it. I don't think that the.
Mr.
scram
Butler,
will detect that. That's
We're
my
not in the
question.
business of taking people's word for things. I mean, I get you, but
You gave him a scram.
he could be drinking a beer and we will never know because he can say it's that.
But the scram detected it.
The scram will detect just alcohol. It cannot tell us if it's that or if it's true ethanol.
Agreed, but.
That therein lies my problem.
So the problem with this particular case was he was unaware of how that, he wasn't even thinking about it. He's just using his mouthwash that he was prescribed. You saw the prescription on the side of the bottle. That's all he's thinking about. I'm just following my treatment. And when he blew into his device, he showed residual. And then, I guess, didn't do the follow-up, which is the problem. So
I mean, I assume
the
that's.
residual amount alcohol would have dissipated.
A 0.04 is not residual.
Well,
A 0.04 is it's probably 3 beers, two and a half, 3 beers.
well, so we do have a scram device that the court is now getting a monitor. So worry to have 2 beers, whatever, court will know about it, we'll lock them out. But I'm just like, he is seriously concerned about.
Come up. You are on bond for a DWI second. You are not allowed to consume alcohol. And I made that perfectly clear to you last time. A doctor cannot subvert a court order. You cannot consume alcohol whatsoever. So it is on you to get back with the dentist and say, hey, look, man, cannot use this. Is there something else that I can use that will achieve the same purpose? But I have many people here that try to sell me the London Bridge, the sun, the moon, the stars. I will never know by using this mouthwash if you're actually using alcohol or the mouthwash. I know what you're going to tell me. Everybody tells me that. I swear to you, Scout's honor, on my daughter's life, on my pinky toe, everything. This is a court, and we work on proof. We don't work on the gospel and spoken word. Do you understand?
Yes, sir.
If I did, people would run over me every single day, all day, because everybody's always trying to take me for a ride.
Well, sir, let me say something. I thought I had made it clear to her as well. So.
To who?
To the dentist, because I told her, because of, prior to going in and getting,
Then
I had told her that I can't have any mouthwash that has any alcohol. And, of course, a month later, this is, the treatments that I was getting with the dentist. She prescribed this. I'm thinking that she knew already that's prescribing.
Before you
I
put,
did not pay for that. That's my fault.
before, and I'm going to give you the benefit of the doubt now, but you're not allowed to have alcohol. And there's no way for me to know whether you're really drinking alcohol or something else. And I can't take your word on it. As much as I respect, and I know Mr. But I've known him for 20, 30 years. It has nothing to do with that. It has to do with you're charged with a serious offense. One of the things is that you're not allowed to consume alcohol. People will use anything and everything to consume alcohol. Like I told him yesterday, isopropyl alcohol, rubbing alcohol, axle grease. They'll do whatever they can to get intoxicated. And the point that we're trying to do is not to hit that, because if you do, it's a very easy to just,
Right. I'll go away from that.
you don't have to throw it
No,
away,
I will.
but
I don't want
what I would do is call the doctor, see, is there another method? This case is going to be done within the next couple of weeks regardless. So it's not, it's already 210 days old. It's not going to fester for much longer anyway. We're just waiting for records, but just, you're in the home stretch now. I don't want anything bad to happen. You understand? I understand that you have issues with your teeth, but there's no way for me really to monitor, Right. Okay. Sorry.
No, that's fine.
Okay.
That's fine. I'll go away from that.
You don't have to do that. Just, right. That's what, there has to be something. I don't know. I'm not, okay. We'll continue supervision and then just whatever date that we had, then it's yours.
All right,
Okay.
sounds good.
Thanks.
And then we're gonna get the reset of the schedule. Okay.
Yeah.
Thank you.
Okay. Take care.
I mean, this being just an amateur work.
Sebastian. we're talking.
VDRs and. This is the one we got picked up. He's about 60 pounds. He's gone tonight on his felony. But we have two VDRs here. There's some.
What was the last name?
Estrada.
Strata.
That sounds right. That's okay.
Well, did they give him another PR bond?
No, I think we have just set it for today for
Oh, it's right. Oh, it's bond denied on the felony.
Right.
And. Okay. Yeah, I'm gonna end up revoking the bond now. So, so he's got the Openberg hab, picks up a theft, now picks up another theft, I guess 5,003. Okay, and then whatever you want.
Yeah. And then the second thing that I wanted to ask you about in this case, we had actually set it for Wednesday originally because.
Whatever you want, sir.
No, it's for discovery. So we had set it, we set it like 2 weeks for, to take out an opportunity to get surveillance. I'd asked for discovery compliance data, of that initial setting, and then we set it 2 weeks without the discovery compliance setting date. As I understand it, there's still no surveillance, still no identity of the.
Well, hold on a second, but if someone goes, did he go AWOL?
No. I mean, he appeared for court dates and everything, and then he has to pick up, the new case.
Sure. What do you say? The case is 131 days old. I mean.
It does. So.
It's still a little too early for me to give them a 10-day discovery hearing, I think. I mean, at 130 days,
I think what we discussed last time is that, I mean, especially because it's surveillance and it has retention periods and everything, we have given them, you know, another reset or something like that. And I think that's what we're at now is that, you know, we're looking at that. And I understand that you picked up a new case, but still doesn't, you know.
What do you think?
I'm just looking at the case now.
Are you asking for me to not let it in? Is that what you're asking for?
No, not today. I'm asking for the, you know, the
He's asking for the 10 day.
Oh, you want the 10-day discovery? What's your reply?
We haven't received just, so I understand.
It's getting kind of up there. I mean, if we do 10 days from today, now that'll be 100 and getting at about 150 days. I mean, not at 150, but you think that you're gonna get it or?
Walmart does, it's been inconsistent with other Walmarts.
I know, it's
so
crazy how, I don't,
some do
is it, I guess it depends on which Walmart you get.
So I just don't want to, you know, present to you that I can get it.
They better be careful once, you know, certain people figure out which Walmart, you know?
I have a running map.
Right. Okay. All right. I'll give it to you.
And there were two things specifically in that one. So it's the surveillance, but then there's also an off-duty cop who actually committed or did the arrest and we don't have this information basically. So.
Oh, wow.
those were the
Okay. Yeah. Then, yeah.
Thank you very much.
Pace. Sorry, on Estrada, 5003.
Yes.
Please.
Right.
Counsel, you ready?
Yes, Judge, I'm approaching on top, docket matter.
Okay.
I'm
Is
traveling from
this
state.
you're on Vega?
That's correct, Judge.
Got it. Okay.
He's a Spanish speaker and the interpreter is the judge.
I'm ready for you. I need to give you a cause number.
The cause number, Judge, on this one is 262-1752.
Veronica, did you get that?
I gave the information.
Great. Hey, can I have a, let me see if there's a bond set. Please. Okay, there is a bond set. All right, Mr. Vega Garcia, you were charged with two cases. You were charged with driving while intoxicated, second offense, also with failure to stop and give information. On both, or on the DWI, you're facing up to a year in jail and or a $4,000 fine. And on the failure to stop and give information, up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay.
Bear just come straight from the DIMS. On May 24th in Harris County, officers responded to a crash call at 10 o'clock at night. The complaining witness advised that he was traveling westbound in lane 3 of the 6100 block of the San Houston Parkway when a motor vehicle ran a stop sign, taking a westbound turn, and struck the right front quarter panel of the complainant's truck. Complainant then followed the defendant's vehicle about half a mile from the original crash scene, where he was able to get in front. Complainant stated the vehicle did not continue to flee due to having a flat front tire. At this point, complainant called the police. The estimated cost of repair is $3,000. Upon speaking with the defendant, officer on scene observed him to have glossy eyes, slurred speech, and a smell of alcohol. Officer observed the defendant to have a wet stain on his pants as well. The defendant advised to drinking 2 Bud Lights. SFSTs were then conducted. 6 out of 6 HGN, 4 out of 8 walk and turn, 1 out of 4 one bike stand. Defendant refused a breath specimen after the DIC was read. Blood search warrant was executed. Blood was drawn.
Does he have a license to drive?
There's not one listed, Judge.
No, Judge, he does not.
Mr. Vega Garcia, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. Because this is a second offense, I'm ordering you not to drive any vehicle that's not equipped with an ignition interlock on it. I'm sending notice to DPS in Austin so that every police officer in the state knows if you're caught driving a vehicle and that vehicle doesn't have an interlock, they're going to take you to jail. You do not have a Texas driver license. You are not allowed to drive. You will be signing a promise with me. This is an affidavit that you're going to swear to me that you're not going to drive. I don't care what you have to do in this life. If you do not have a license and insurance, and in this case now a guardian interlock on the car, you are not allowed to drive. So I am now making it that you are not allowed to drive. If you do, I can have a contempt hearing and you can be facing an additional 180 days in jail and a $500 fine every time you drive. Because you are not allowed to drive, you will get a portable device that you're going to take with you everywhere you go to prove to me that you are not consuming alcohol. If you fail to blow in the device, I will put you in jail. If I have to revoke your bond, I will end up revoking your bond on 2 cases, and you will end up having a high bond. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, they may very well put a detainer on you, and you could be in there for many months. Do you understand?
Yes, sir.
Do not drive above all else in this short life that we have. There's no better way, that and consuming alcohol, than to make us extremely upset. Do you understand?
Yes, sir.
I will not warn you again. Has he made bond on the cases?
I believe he has. and
Great.
he's allowed out. I'm surprised that I did not pick him up, Judge. But he's here.
I would warn your client, accordingly, because if he goes in another time, he may not get that lucky again. Yeah, just remember with the portable device, if he skips any test whatsoever, he will go to jail. Okay. So for now, I'm going to have you come up here, swear a test that you're not going to drive. I'm going to have you sign a reset. You will be tested for illegal drugs as well, just so that you know. Once you get your conditions at that point, you guys are free to go. Okay, of course.
Stuart Terry.
Oh, great, thanks. Ramona, usually Victoria is usually the one that files the interlock paperwork so that we can send it to DPS. You did? Okay, good. All right, thanks.
Judge, we have one, arraignment.
When did they show up? Did they just now show up? Okay, so let's get all this stuff done first and then we'll address it. Okay, good morning. This is Mr. Barrett. Mr. Barrett, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 48 days in jail with credit for the 16 days that you have done. Is this how you understand it?
Yes, sir.
It also is alleged that you have a prior enhancement. Let's see what that is. It's alleged here that you have a prior theft from 2018 from County Criminal Court at Law number 11. Is this true or untrue?
Yes, Your Honor, that is true.
Do you know now what happens if you ever pick up another theft, Mr. Barrett?
Yes, Your Honor.
What happens?
Yeah.
No. You were looking at prison time next time. You were looking at a felony offense. A third theft is a felony and you're looking at years instead of days. Do you understand? You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change this or undo this. It will be on your record forever. This is what you want to do. How do you plead to the offense? Guilty or not guilty? I'm going to find you guilty. I will follow the agreement, sentence you to it. Good luck to you, sir. Thank you.
Thank you.
Deputy Williams, are you ready on the other? Okay, still. I don't know who it is. I have one, okay. Ramona, are you ready for this? For this arraignment?
Yes.
You ready? Why are you so late?
Your Honor, I have no reason other than my daughter.
Okay, don't be late again. We write everything down. If you're late again, it just messes everything up. You understand? Next time you must be here at 8:30 in the morning. Ms. Avila, you're charged with driving on a suspended license or driving on a driving on a suspended or revoked license. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. If you cannot afford a lawyer will be appointed to represent you. Okay.
On May 23rd, officer on patrol observed a motor vehicle with no front license plate and no lights for the rear license plate around 1:15 in the morning. Traffic stop was conducted. Defendant driver advised that the license was expired and she was identified by her Mexico passport. Driver's license is not eligible.
All right, Ms. Avila, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to drive. You do not have a Texas driver license. You do not have insurance. You are not allowed to drive. You understand?
I do have insurance.
Okay, you don't have a license to drive. Until you have a license that's eligible with TPS, you're not allowed to drive. If I find that you drive, I will put you in jail. How many children do you have? Okay, imagine who's going to take care of that child if I have to put you in jail. These are the things that you need to think about when you're in the free world, because when you pick up cases, it's just, especially repeated successive cases, I'm not asking much from you. I'm just asking you to follow the law. If you do not have an eligible driver's license with DPS, you're not allowed to drive. If you were able to go get your license back from DPS, then I'll happily change this. But until that point, do not drive. It is your responsibility to get in touch with DPS to find out what you need to do. But until that point, do not drive. You understand? You're going to be signing an affidavit with me today, promising you're not going to drive. I don't care that you have kids stuff. I don't care that you got to work. I don't care that you need groceries. I don't care that you got to go to the hospital. There's no justification. Do you understand? So, do you have the ability to hire a lawyer? Are you working at this time? How do you support yourself? Okay. Deputy Williams will give you an application to apply for a court-appointed lawyer. I don't know who you have in this life, man, but if I have to put you in jail and make your bond $5,000 to $10,000, if you don't have anyone to put that kind of money up, you're going to be with me for a long time. I don't want to have to, but just follow the law. If you need anything else, we will give you a lawyer. I'm not asking for much. Do you understand? Okay.
State's conditions, right?
Yeah, please, no driving.
Yeah, no doubt. It'll be. Sure.
Judge, do you have any more apps up there?
Who you waiting on?
Right?
Was there? That's it. Not getting correct. I mean, considering nothing. I need to go up. I assume because they made
Right? Somebody is filling out. I'm making another spring. Oh, thank
You should have said he's done. Okay. Yeah. Yes, sir. Yes. She is the chief of the including the.
Hey,
One. Yeah, I think it was people.
Over here.
Yes, Judge. I was turned around.
it's, hey, Frank. Can I talk to you for a second? You have a client, Peralta, your client, has bond violations. Uh-huh.
Oh, yes, no, he's on probation out of San Jacinto County. When they found out that he had a DWI, they filed a motion to adjudicate. So he went, turned himself in last Thursday.
He has a bond violation here. He failed to show for a
Right,
drug
because he's
test.
in jail. In San Jacinto, so he's not, he has court on this Thursday coming up. In San Jacinto County, and then they're trying to get a bond on the motion to adjudicate. I looked at the motion to adjudicate already, and there was no other violation besides this case. The only other violations were money. He was behind on money as far as being positive for drugs,
This is a
not
big,
reporting.
it's a big violation, but allegedly.
Right, this allegedly, right.
So was it a felony or misdemeanor?
He was on probation for a felony.
What?
He was a possession of controlled substance. It was 4 years. He had been doing 2 years already. He was ready to get off, basically. And I looked at the motion.
Mr. Hyde, what do you want to do?
He is offering plea agreement today.
He's in jail in another.
No, we're talking about somebody else. You're talking about-
Oh, no. We're talking about, I need to give you a cause number.
Got it. I can see it.
Okay.
Pull it up.
He's on, I don't know if I even knew that he was on felony probation in another county. But
What's our charge here? DWI. DWI second, he's on probation for DWI.
no. Well, I don't know.
That's in
Okay.
But it looks like they just took him into custody over there.
He turned himself in. Okay. He
Okay,
actually went and turned himself in. knowing that-
that's good. But can you see if a bond is set?
No.
At best, I'd be able to see if there's a charge pending, which I see a charge pending, third degree felony. And just into account.
So what do we do?
I mean, we're talking about addressing bond violation, we've had to see he has records and ID.
Are you representing him over there?
They want me to represent him, and I'm telling them, I can't be there on Thursday. And so I said, I told the family, you want to get somebody else, you're gonna put a lawyer. The only violation is this case. I'm representing on this case. This is the case where you first got put.
So he's got court Thursday.
Here,
No, you're saying he has court
He's got
Thursday there.
court Thursday.
Why don't we
He's in jail
put
right
this case on for maybe the Monday after so we know what happens? Where are you? Are you going on vacation or something? When are you going?
I'll be back on just Thursday. I'll be back in court. Not this one, but the following.
When are you leaving?
I'm gonna leave next one, next Thursday.
Are you leaving on the fourth?
I'm leaving on Thursday.
Which is the day that he has court.
Right, I'll be back on Wednesday. And again, I can, as an officer of the court, I can tell you, I saw the motion to adjudicate. There was no other violation.
I know, I believe you on everything. The only problem is how do we address everything here? Because I don't know. He's got to, I mean, now that he's in jail, he's not testing, he's not.
He won't be.
He's in complete non-compliance with our bond conditions. And I understand he's in custody. I'm not gonna hold it against him if he's in custody,
He'll
but,
be out, Dr. Rowan, he'll be out.
well, we don't know
Hopefully-
that.
Hopefully he gets a bond, because the only violation was that besides the money, only money.
Can he get a bond?
He's done it first, so he's entitled to a bond. What the judge, what the bond's gonna be, I don't know, you know, sometimes they'll give.
But he's a citizen?
Yes, he is.
Okay, all right. Hey, Ramona. Can I give you a cause number? Please. It is 261-7240. So he's currently in jail in Jefferson, or no, somewhere else. I don't want
Okay. I speak
Leonard
English.
Holmes.
to. No,
Yeah, I mean, I see.
Peralta.
That's
Let me give it to you again. 261-7274.
I don't see he has a driver's license either.
Okay.
He had an immigration hold in 2019. I don't see he has a license. I don't.
That was my question as to why can't he get a bond? Because
Yeah, I don't know, he speaks English and I assume.
that's why I asked you if he was,
I
if he,
assumed he
He was only in
because,
custody for about a day a year, so.
so what day do you want to set it on?
I mean, I can be back next Thursday, Judge, not this one coming up, but 2 weeks.
So you want to do, so you said you're gone, you're back, so how about that Thursday, the 11th, June
I mean, I
11th?
gotta be here anyway at 11, yeah.
Okay.
Not the 11th, not the 11th, where that's like the day. I can do it.
Oh, how about the next day? You do that Friday?
That's Friday.
Sure. I'll be here.
The Friday? Yeah.
Yeah, okay.
Guess I'm here. Okay.
Okay. So what I'm gonna do is I'm gonna send both of you guys an email pursuant to our conversation. We are placing this case on the docket for June, what was it? 11? 11? 12. And the defendant must appear. If he fails to, his bond will be revoked. If he's in custody, obviously, I'm not going to revoke it if
Okay.
he's in custody still. But if he's out, he's got to be here.
Definitely.
Okay, let me make sure I got you. I will add Ramona, Stanball, John Hyde, Sean. Okay, I think that's everybody. Okay, cool. Let me go back to right here. Did you want to talk about anything today? Did you have something today?
Second, Judge, can I approach the bench?
Of course.
About 5 minutes?
Yeah, take your time, no rush.
Judge, we also have another arraignment that you should go with.
Dude, you're killing me, Smalls. What the hell? Did they just get here?
Yes. Judge, when you're ready.
Yeah, bring him up, please.
Laura.
What's the name?
We'll say, to make it.
He had a case dismissed, a felony theft dismissed 9 days ago. What time does court start, Mr. Wilson? In what world do you live in? Denial? What court starts at 12 o'clock, bud?
That's what they had on my paper.
Show me. Show me.
I did, they did say switch to him on my paper.
Go get it.
Oh, Judge, it does state,
I don't have my paper.
but
Who?
it was this morning at 12. Like,
12 a.m.?
it was midnight, yeah.
What?
That's what's on the paperwork. Look at the bond.
Let me see.
Sent a rainman on.
Weird.
Weird.
I saw them in the early song.
It's just midnight.
What the hell's wrong with these people, man? Mr. Wilson, you're charged with theft. From now on, court starts at 8:30 in the morning. It doesn't start at noon. This is not our first rodeo. This is not your first court case. You know what time. So I'm not going to hold anything against you, but from now on, 8:30 is when court starts. You're charged with another theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
The judge would say, theft from Walmart, the Walmart LPO, loss prevention officer observed the defendant on surveillance picking up an item, pulling wire cutters from his pocket and cutting sensors off of the item. Defendant attempted to exit the business and was stopped and detained by loss prevention. Total was $353.97. Item was a wheel and shifter bundle for an Xbox console.
Tell me, of all the 3 prior thefts within the last 10 days, are there others from Walmart?
Yes, Judge.
You will now get an ankle monitor on your leg, Mr. Wilson, and you're not allowed to go to any Walmart whatsoever. If I find that you go to a Walmart and I don't give a rat's behind what your excuse is, I'm going to throw your butt in jail and I'm going to make your bond high. Do you understand me? We are going to reset your case to give you time to hire a lawyer. I'm going to have you sign a reset and then I'm going to have you take a seat while we get your bond conditions. You will get a monitor and I'm telling you, if you go anywhere near a Walmart, it's not going to go well between us. Do you understand me? Come on. Wow. Can I give you a case number? Can I give you a cause number, guys?
Yeah. One sec. Okay.
2606816. You don't see many tamperings with the electronic device, you know? As much as we get it,
They did all the news, like.
you know, right, and I'm surprised that they're filing more of them now, but
That's, and few violations are in addition to what he's here for.
I had put them on the docket for Monday because of the bond violation that they had, even before they filed these felony cases against them.
Yeah, and they'll probably be filing more tampering cases. Plus, I mean, the tampering charges are also new. That was only, that was passed in the last legislative update.
Yeah.
So you'll like to see more.
You'll go through it. Hey. I'm granting Avenue.
The first one on page 4.
Contreras, 2501. Davis on top of page 5 got dismissed.
Yes. Because I was on page 8 is it's supposed to be for right now 6-1.
Yeah, then just
No. Farms teaching out.
The next one is yeah, on page 11.
Yeah.
2501.
And then
Same thing, 2501. O'Brien. Is that next?
next,
Same thing, 2501, and then under it again.
right, okay. Okay, and so on page 14, read. There's a surety bond that has today's court date on it.
So-
And for the other one that says 6-1, both of them should have been on page 8.
Okay, so 5,002 on both. But why does it say 6-1?
I don't know, Judge, I guess it's just an error. But the bond paperwork says 529.
Okay.
So the other case is not on until Monday.
Just leave it, yeah, and then we'll, but on ours, 5,002.
Okay. Same thing on the next page 15.
Okay, I have to do a bail order on Reed real quick.
I'm holding on to the case. You got
So you said Renture is the next one,
Yes,
Ramona?
sir. And that one is the same, well, yes.
Another failure to be, so 10,003 on both.
The other one is on Monday, I believe. If that one really is on Monday, I don't know.
Yeah, so this one, he's not here, 10,003, and it's a third non-appearance. Hello,
Good morning, Your Honor.
thanks for coming.
How you doing?
Did you just get appointed to a case?
No, sir.
Oh, okay.
This is for Mr. Paul Jones. He's on docket for Monday. This was the case we were ready for trial for, and he was at home sleeping.
Oh, right.
Photo.
So what happened is, did he bond out?
He did. Yes,
Okay.
sir. So, Monday, I have to be in Fort Bend at 9. I'm gonna be there at 8:55, so I can hurry up and be here.
You can zoom in.
I can zoom in?
Yeah, that's why we have it. Just to make your life easier.
Judge?
But no, but for real though, right, that's why we have it.
Okay.
Right, you don't have to hurry up here,
I just
just
wanted
zoom
to-
in.
I want to clarify that. Now, how will we handle it?
That's a great question. I don't know. He may not even show up on Monday. So if he gets here, on that point, we'll address it. I have no idea.
Yes, sir.
Let's wait till Monday and we'll see if he shows. We'll go from there.
That is-
Yes, just feel free to show up anytime. I mean, before 11:30, hopefully. But yeah, and don't meet a bathing suit.
Okay. All right. We'll do-
But other than that, yeah, have fun in Fort Bend.
Yes, sir. How do you know this?
Because I.
Here, see my-
I'll be fine.
Here's my favorite one. My favorite one. There's my honesty. You think I'm there? For Starbucks? Oh, my God.
Sure.
Oh, I'm on vacation. I'm flying all down from the camp.
But it won't be on. All right, you too.
A Walker Pond, top of 21, is that the next one? Hey,
Yes.
oh, that's also a June 1st case.
Well, we need to be. I know. Media signature. Yeah, she's gonna get on a little bit. Yeah, she can be.
So.
Yeah, is it on there? It's not on there? We should write it. What's the name? That's awesome. ADO. Underscore AA. That's awesome. Yeah. I sent her an email recently, I didn't hear you. She kind of have an awful female, but I see her on the email. You got
So Brian, that's a game.
Yeah, the coordinators have to file something, with somebody and ensure that it's not for the one for future.
Yeah. I had it talk to her.
She's the one who handles all, whatever.
You don't have.
Yeah, I mean, I'll defer her. Okay. Yeah, that's all I need.
Hey, talk to me. What's up? Yeah, you're telling me.
Okay, I'm here on the bench, you know.
Yeah, how'd it go?
Everything's great. Every guy stepped into the court.
Did he do he did the,
He did everything's done. The only thing is, wasn't aware that as, I figured it was benefit or it's different, but.
They're trying to
Yeah,
get 5 days in jail.
in jail.
Oh, really?
Right, so I've asked the state if they'll reduce the class B, which will eliminate that. Unfortunately, Caitlin, the officer was the one that was approve it, so.
So I'm not gonna, this case is 250 days old.
I know.
No, I'll set it for Monday.
I was gonna say, can we
But-
wait till Tuesday maybe, because he thinks that she may not,
Well, so
email.
I've been getting that office email, but she's been responding to some emails sporadically. It doesn't say when she comes back. She didn't
Fine,
answer.
okay,
that.
two-
We'll do
but-
Tuesday, and if not, then
Yep.
we set up
Yeah.
the trial.
That's- Oh, no. You set up for trial, we are gonna go for trial. I'm not gonna accept
No,
anything.
I understand, I know, I'm
Yeah,
just,
he needs to plead on that day. That, it's now nearly 300 days old.
Okay.
No. Tuesday's the last day.
no, I understand. Yeah.
Okay, all right, you got it,
Thank you.
for sure.
She is over, so, prefer.
Okay.
Oh, okay.
Yeah. All right.
Yeah. Sure. Yeah, look, have a great weekend. I'll thank you. Thank you.
Then he was walking to the court.
All of that is.
More value.
Okay.
Oh, sure. Whatever you have.
Oh, sure. No worries. Okay, there's not a number in there. That's
Well,
pictures,
I put
yeah.
I put 5,003.
Yeah.
Oh, weird. Okay, sorry about that.
Have a great weekend. Thank you.
Good weekend,
Bye. Take care, guys. You too.
You too, take care. Yeah, rather than you
Okay, thank you.
It's great.
Hey, you got Richard back there? Dylan Richard? No? You still in practice?
Follow the streets and right. Yeah. You go to the project. Thank you. We'll be going back to both.
Some.
I think the difference may be in this one here, John, that he took it all the way off, allegedly. And I think as opposed to just trying to manipulate, you know, maybe that was,
Versus. removal.
yeah. Mhm.
Yeah, I don't think I've seen the tampering charge when all they do is just tamper with it.
Yeah,
It's still
yeah.
kind of where they're able to get it fixed. Usually I see removal.
Hey, we're close, right? Ramona? Are we close? Or who are you waiting on?
need.
There was one attorney that was going to approach on the VR. She's gonna approach on,
Oh,
what was it saying?
Red Rose Val, we're waiting on Sean drinking the freaking.
got it.
We're waiting on Marjorie,
Right. You know,
Through early.
but I just requested it at like 11:30,
what's last name, ma'am?
right?
Riley?
Right.
Or right, she still needs to come sign it. At least we can have her sign the bond conditions.
Oh, okay. Maybe when.
Come up, we'll have you sign the conditions so that's ready to go. You said her name is Revuelta?
Yes. Okay.
So, I want to send her for a drug test. She's already skipped twice and she's going to get a scram and then we'll address it on Monday. But she's already skipped 2 tests. I need to find out what's going on.
Okay, yeah,
So-
we were ready to explain everything. I wanted to just kind of negotiate with the state before doing so, because in the event that you allow her to remain on bond condition, those and then.
I am, but first, I mean, for now, yeah, come on. So I'd like to send her for a drug, an
I assume
alcohol
we're gonna do
test
that
now,
this morning.
and then
And this is right.
for the time being, a scram. And then we'll address, if it's clean, then I'll continue supervision. If it's dirty for anything, then we'll have to address it on Monday or Tuesday. You
If
pick.
it's clean, we don't need to come
Yeah.
back.
Hmm,
Okay.
hmm, hmm.
Is this grant?
Come up, Mr. Revuelta.
Can we do agency pay for this grant?
Don't I always pay for everything?
Just making sure that you're aware.
You have already missed 2 drug tests. 3 strikes. Guess what happens? I'm not making a decision right now, one way or the other, but I'm sending you for a drug and alcohol test. I've ordered you not to use. This case is now over a month old. I guess you're going to get a scram on you now, just so I know over the weekend that she's not going to use. And then we'll see Monday what the results of the test are. So I'm ordering you to come back here Monday. We'll see what the results of the test are and we'll go from there. If it's clean,
Come back for the results.
I guess,
I guess in the end.
yeah, send an email. If it's clean, then I'll continue supervision. If it's dirty, then she's got to be here.
Okay,
If
so maybe,
you ever miss again, if I continue you now, because I'm not making that decision now, I'm depending on what the test says, but if I do continue you now, if you ever miss another test, and I don't care what your excuse is, you know what's going to happen. There's no excuse for any further bond violation. I don't care if it's with the scram. I don't care if it's with anything. It's absolute no tolerance going forward. And we'll see what the test holds Monday. I mean, I'm not going to commit.
okay, so potentially, it sounds like we would have to wait Monday for Trial to send us the email, and then if.
No, so we'll get the results today. She'll send us an email today. And so we'll put it on the docket. We're going to put it on the docket for Monday.
Okay,
It'll be waived if she's
Got it.
negative. If it's positive for anything, including marijuana, you must be here and we'll go from there.
understood.
Yeah,
Understood.
she'll get a scram now, so we know that she's not going to use. And we'll address everything on Monday.
Okay, thank you.
Okay? Yes, ma'am. Please.
Maybe we just.
Yes.
Maybe good.
Oh, yeah. Judge, we have some news to break to you. We broke it to the rest of the court staff, but
You're leaving.
Sean and.
Wow.
Both.
Both of you, come on, man.
I know. I am going to court for.
But you just got here.
I know. Listen, this is not my request. I enjoy my time here.
Yeah, it's been a
I
pleasure
try
so
to find
far.
alternative ways. It's been a pleasure, but they're probably otherwise.
Tell me, are we getting a chief?
You're getting a deputy chief. So you'll keep
Oh,
deputy
wow.
chief. You're gonna get Karina Batista. I don't know if you're familiar with her.
I don't
but
think so.
She's still a deputy chief, so PTI decisions.
Great, wonderful.
Change for you, so that's good news.
Great.
Sean's going to court 1.
Okay.
Judge Salgado. And so, but he's probably gonna hang on to a couple trials here, maybe that.
Do it. I'm happy. Yeah. I mean, we have that one animal cruelty one. I
That's
mean,
the one I
I'm,
want.
Yeah.
And then there's a DWI coming up with decent that I think I'm gonna keep.
Yeah.
that's good experience right there too.
I always told
That'd be
him,
why.
trying cases against good attorneys is always preferable.
That's how you really learn is when you try it against good lawyers, because that's when you really pick it up. You know, when I first became a defense lawyer, I did everything I could to learn about DWIs. I'm telling you, I went to do the field sobriety test training classes. I went to the interlock training classes. I went to classes where we did DREs. So I learned how to become a DRE. So I knew exactly what was going to happen to my client, when and how, and whether the officer did right or wrong, so that I know, you know, and to learn it from, yeah. Anyways. Well, I'm sorry to see you guys go.
I know.
So Mondays,
It'll be.
today's the last day.
Yes, today is the last day. I put off on telling you because I was gonna see if I can get that. If I could find some other ways to stay here.
Really, it's not a big, please.
Yes. Okay. Are we?
She wants to continue to contact and she was interested, so she does want to come back.
Very much.
Thanks. It's okay, really. I'm glad that you know, this.
I've enjoyed my time while you're judge, so I just want to say.
Yeah, Sean, it's been a pleasure. So what about Farwell?
She's
Okay.
You're gonna get.
Where's she
Sarah
been?
Anita.
Where's she been?
She's on, she's got a wedding up in Ohio.
Oh, she's gone for personal reasons. Got
She'll be
it.
back.
Okay.
She'll be back.
Well, have fun. You're going to, I think you're going to relatively good, you know, she's nice. I don't know how things are done. I can't, but, and I think that Alex is a great guy too, really easygoing. You're going to a good, you know.
You'll get an envelope.
If it wasn't anything, that was all.
Sounds great.
It's been
Um,
fun. I mean, I've only been here for like 3 weeks, but I've really enjoyed my time here. Everyone's so pleasant to deal with.
Well, that's,
You know,
the idea is that
environment.
we all get along, we all have a goal to achieve. You know, when you fight with everybody, it just makes life so much more difficult and
That
just,
really
just
does.
wait to the
And
end
I've been
short.
to some courts where the judge can be very unpleasant and then it trickles down to everybody else.
To everyone, to everyone.
You
I,
know, staff is having a bad time, the attorneys who are having a bad time. So,
20 years ago, I went to a court here where there was a judge who was always so damn unpleasant. He literally ran out coordinator after coordinator after coordinator. And I think he blew through in a very short time, 6 coordinators. And I went in there because I was just late one day and I forgot my tie. And I was like, you know, I went in, he kicked me out. He kicked me out and said, get out. You're not allowed in here. No tie, get out. I'm like, so I went downstairs. I borrowed a tie from one of the security guards, came up because I still had my client to represent, you know, and just really, really.
Yeah.
I-
I've been in those courts too.
So not necessary.
Thankfully, the bailiffs kept ties for that reason, but I've been in those courts too. I mean, there's just so many judges here. We have so many courts that you're gonna get such a smattering of personalities, but it's been a pleasure to you.
Yeah, wait to get the felony court. Then
That's what I keep hearing, so.
depending on, you know.
Yeah, there's some great places and there's some real bad places.
How many trials do you have to get until you go up there, do you know?
Right now, I've been through 4 trials, 2 verdicts.
Is there a specific number that you have to have before
You
you?
know, I think what's gonna happen is when we get our big batch of pre-commits in August, he'll probably be promoted. I think everyone who is here now is going to get promoted once we get our pre-commits, minus, you know, the few new attorneys who come through.
Granted, you're gonna have a lot of pre-commits?
We have 43.
Whoa,
Yeah.
wow,
Huge amount,
that's awesome.
which is good.
Great.
Need some more flow.
Yeah,
So-
you need to fill all these spots.
Yeah, and plus, I mean, the pre-commits, some people fail the bar.
Well, right, yeah,
Statistics, you know.
that's a lot.
So we'll need some backup. We're excited for that. We can make up something.
I think we're done. Ramona, you want to reappoint?
I did.
Oh, you did?
I did.
Who, Mr. Bell?
Yes.
One, okay. All right, guys, we're done.